Good morning and a very warm welcome to this, the third SRB Legal Conference. And we're coming to you live from the SRB building in Brussels today. My name is Susan Carroll and it's my pleasure to be your moderator for this event. We've got a very exciting lineup for you and I'll shortly hand you over to our chair, Dominique Leparex, to officially open the day. But before we officially start, just a bit of information from me about the format and particularly how those of you joining us online can take part. As you can see in our agenda, we have a welcome speech, a keynote speech, and 3 panel discussions with 1 short break and a lunch break. Towards the end of each panel, the moderator will invite you online to ask questions or make comments. For those of you joining us via WebEx, you can simply enter your question into the chat throughout the panel discussion, and the moderator will come to you in due course. For those of you in the room with us, I think we'll stick to the very old-fashioned method of raising your hand. And a final hint to our speakers and moderators, our event today is public and we are on the record. Now let's turn to our official welcome from Dominique Leparex.
Good morning and welcome to all of you, whether online or here at the headquarters of the SRB in Brussels. So this is the 3rd edition of this SRB Legal Conference, which really is now an important hub, fostering a common culture of sharing knowledge on resolution matters with practitioners of law and finance, academics, and public officials. This is absolutely in the spirit of the new SRB strategy for the coming years, the so-called SRM Vision 2028. I want to thank all of you for contributing to that goal by your presence here today. Once again this year, we are delighted to have outstanding speakers, and no doubt there will be room for the audience to ask questions and to challenge you as speakers today. So you will be in the panels and you will be confronted to specialists asking you to explain them how you see the topics of the day. The title of the conference today is called Navigating Legal Frontiers in the EU Banking Union and Beyond. Don't forget that at the end we will ask you if you understand the title of this conference. The discussion will be focused on the frontiers, as said in the title, of our resolution framework, the frontiers of our judicial framework, but also operational frontiers stemming from EU or national legal specificities. Some topics to be discussed today will be connected to some of the lessons learned from the recent 2023 crisis cases. And indeed, the banking turmoil in the US and Switzerland of last year put the banking resolution framework in the spotlight and reminds us of the importance of crisis preparedness within our own framework, the single resolution mechanism. There are certainly also lessons learned from these crises from a legal perspective on the completeness of our framework and on the way of implementing it. Our goal at the Single Resolution Board is to protect financial stability via the Single Resolution Fund, why not, without using public money, taking the necessary decisions on resolution. But of course, we must be confident that our decisions will stand up to legal scrutiny. As many of you know, the Single Resolution Board is tasked with ensuring that around 110 of the largest banking groups in Europe are resolvable. The Single Resolution Mechanism, made of the Single Resolution Board and the 21 national resolution authorities, has to deal with a wide variety of countries and banking systems in the banking union. The complexity of 21 different legal systems has to be taken into consideration in our preparation and planning for resolution. Beyond these general considerations, let me take a brief look at the panels today. The first panel will look at resolution transfer tools and legal challenges, as well as the impact of digitalization. While most of our banks have bail-in as a preferred strategy, we have more or less 80% of our banking groups under a bail-in strategy. We must be prepared for different scenarios in resolution. In this sense, the use of transfer tools or the combination of tools, bail-in plus transfer, could be an alternative strategy at the time of crisis. being flexible and prepared, be it in resolution planning or crisis times, is key for any resolution authority, and in particular for us, a Single Resolution Board. When a bail-in is not implementable in a fast and efficient way, then the use of alternative strategies needs to meet both national and EU legal requirements to be equally as credible and feasible in resolution. For instance, the national requirements to set up a bridge bank in terms of licensing, in terms of funding, and other operational settings, dependent on national specificities, might pose difficulties if not prepared well in advance. This is especially true when we think about the limited time available for a resolution action. Having a prior sound and detailed understanding of these national particularities is essential for being ready to handle a resolution and to get the flexibility requested at the time of crisis. In this sense, sharing knowledge today and cooperating closely among legal experts from both Europe and from outside of Europe is essential. We must improve our work by taking advantage of operational opportunities such as digitalization or artificial intelligence. However, this will also trigger legal discussions. For example, in implementing transfer tools, resolution authorities should get timely access to the best available data. Sharing this data with relevant stakeholders using the most advanced tools could trigger legal requirements around confidentiality and data protection. Let's look at panel 2. This panel will focus on judicial protection and international investment arbitration in the context of bank resolution. This panel intends to shed light on the workings of judicial protection before the EU courts and international investment arbitration, which is an important but rather unknown element of legal remedies in the field of banking supervision and banking resolution. It will also try to explore the different issues which the coexistence of arbitration in and outside the EU raises with regard to the normal, traditional legal remedies before union courts. By the way, we are exactly today 7 years away from the Banco Popular case. It was decided in the night of the 6th and 7th of June 2017. Here there are some people who spend the night discussing the case, and I'm one of these people, definitely. So we did not select the date of this panel on arbitration due to this celebration, but still it's important because indeed, even if the litigation stemming from this case is still triggering legal questions via the traditional court, well, there is also arbitrage here. And in addition to these procedures in front of before EU courts, the Spanish authorities have faced arbitral proceedings against third country investors up until 2023. So this illustrates well how different fora have been and continue to be used by investors to pursue their interest, also beyond what would be possible within the EU in a resolution case. So they go beyond the EU framework to go to another avenue for protecting their interests. That's why it's important that this conference sheds some light on this topic. The panel 3 will deal with a global approach to bank insolvency, and here we'll look at the possible avenues for handling small and medium-sized entities in financial distress. It's fair to point out that the global banking regulatory architecture left untouched the situation of small banks to be liquidated without any additional solution. They are supposed not to cause systemic damage. However, as we have seen in the US in 2023, even a so-called non-systemic bank can provoke a beginning of a systemic crisis when it fails. From that perspective, more harmonization would be welcome, in particular in the European context. Today, the consequences of a bank liquidation are not the same in the different European countries, which has indirect consequences for the resolution framework, because resolution is always confronted with a comparison with other elements coming from the liquidation regime. We have to ensure creditors that they are not worse off in resolution compared to liquidation. So we assess a common resolution framework against 21 liquidation frameworks. And when opting for the public interest of a resolution action, resolution authorities have also to assess the consequences of a liquidation on the national deposit guarantee schemes. And here again, there is no sufficient harmonization. We have much more than 21 DGSEs for 21 member states, members of the banking union. Today, we do not have a set of international standards nor mechanisms for adequate coordination and cooperation. In this regard, we welcome the work done by the UNIDRA Working Group on Banking Insolvency, which addresses existing gaps in the international legal architecture. It's a good step forward for strengthening and fostering a harmonized approach for small and medium-sized banks. The panel will present its recent findings and potential solutions for approaching the legal challenges for these banks in financial distress. Ladies and gentlemen, let me conclude, fellow speakers, and it will be for you in a minute. I'm coming to a close indeed. We have today a very, very wide variety of interesting points of view to be put forward today, and I'm keen to let them be heard. Thank you for your time, both speakers and participants. Thank you also to those who've prepared today's conference. It's important and valuable to be able to take a step back, gain a different perspective, and listen to those who have new ideas as to how we might strive to make our financial stability framework work even better. Thank you very much.
Thank you very much, Dominique. And with that, let me introduce our keynote speaker today. So we're delighted to have with us one of the foremost experts on financial crises. Andrew Metrick is the Janet L. Yellen Professor of Finance and Management at Yale University. And he'll talk to us today about fighting financial crises in the 21st century, a new playbook. Over to you, Andrew.
Thank you. Thank you very much, and thank you for the invitation to come to Brussels. This is my first visit to Brussels. It's wonderful to stand out in the hallway and hear all the different languages, sometimes in one conversation, in one sentence even. So what I'm going to talk about today is fighting financial crises in the 21st century, which is, of course, where we are now, and so perhaps we should have a playbook that doesn't come from the 19th century. Now, the SRB, of course, is quite far along in thinking about what to do in the 21st century, but many central banks still have rules in their head that were given to us by Walter Bagehot in the 19th century. So trying to think of what can we do to take the last 150 years of history and put it to use so that we have rules that are appropriate for now. So we have at Yale, a Yale program on financial stability, which we think of as a global hub for the creation and dissemination of knowledge about financial crisis management. Started this about 10 years ago. And we have four main activities. The first is an annual Systemic Risk Institute, which we do in the summer. And at that institute, we have a variety of activities. We have one group of rising star, kind of middle-level people who come and hang out with us for a while just to talk about what they would do to fight a crisis. We have a forum where we invite senior speakers to come, and we have an academic conference. So that's all part of our institute. We have a master's degree in systemic risk that we have for young people. And if any of your institutions have young people that would like to spend a year at Yale, we are available, and we're delighted to host them. We have a journal of financial crises that's different than a normal academic journal. So we try to publish things in this journal that wouldn't get published in normal academic journals, the types of things that end up often buried in the archives of official institutions because there was no great outlet for them. So we don't want that knowledge to be lost. And then finally, we have the new Bagehot project. And that's what I'm going to be talking about today. Bagehot, This is a very hard name for Americans to say, so we have this up on our website, and everybody always mispronounces it. So if I had it over again, maybe would have chosen a different Englishman to name it after. But Walter Bagehot wrote a book in 1873 called Lombard Street. And it is remarkable how often people will still quote the main dictum from his book. Lend freely at a penalty rate against good collateral. He says nothing, by the way, about it being a solvent institution. That's a modern creation that we've put in there. But he says, lend freely at a penalty rate against good collateral. This is advice when it was originally written for the Bank of England under the gold standard. And in fact, that's what it was quite designed to think about. They had to lend freely at a penalty rate because they were afraid of running out of gold. That has driven a lot of their decisions. It wasn't moral hazard that they were worried about. They were worried about running out of gold. Okay? But it is remarkable how often when you talk to modern central bankers and people who study it, and you say, well, what about this lending program or that lending program? They go, well, doesn't that violate Bagehot's dictum, and as though somehow this was given on a mountain as a commandment. So what's been our experience? And we really have done a lot of other things, and a lot of the modern emergency lending is done not really at a penalty rate. We've already spoken a little bit about the crises that happened in 2023. The United States government set up the BTFP, or the Bank Term Funding Program, which was incredibly generous. I mean, you could say there was a little bit of a penalty rate, but the collateral rules were so wonderful that it was better than anything you could ever get in the private sector. That violates Bagehot's dictum, but I would argue was actually quite an important and interesting thing to do at that particular time. So what should the principles be, and how should we think about it? And this is really the first place. This took us a while to create a taxonomy, and I hope, oh, that's way too small for me to read even from here. But I can explain schematically what's going on. This is a balance sheet. Okay, so over on the right-hand side is something that doesn't count as part of the balance sheet, but the rest of it is a bit of a balance sheet. So it's a T. Can't really see it all that well, but there's basically a T down the middle, right in the middle of guarantees and restructuring. There's a very thin line separating the assets and the liability side of this balance sheet. And emergency lending is something that affects the top right corner of the balance sheet. Things that written in very small type that only the youngest people in this room will be able to read. The very type of lending in green is ad hoc emergency liquidity or broad-based emergency liquidity programs. So that's one piece of the balance sheet, and that's the piece of the balance sheet that we've focused a lot of our attention on, because that historically, when thinking about fighting crises, of course, that's not what the SRB does, and that's not what a lot of modern crisis fighting does. It works throughout the entire balance sheet. And when we are dealing with a crisis, we really have to think about coordinating our activities across the entire balance sheet. My short version, when non-specialists ask me, well, what causes financial crises, is that it is a balance sheet problem. Okay, often we specialists think about, is it solvency or is it liquidity that really is driving it? But historically, the vast majority of liquidity problems, vast majority of liquidity problems that happen at individual institutions are related to solvency. Okay, so you have your money in a bank, you think that money is safe. If there's some chance that the bank will go out of business, it's suddenly not safe, and the bank has a liquidity problem. And that really describes the vast majority of things, the liquidity problems that are symptoms of solvency problems, rather than some independent thing where everyone woke up in the morning and decided to take their money out of a bank, which is really fun in theory, but does not happen in practice. So therefore, if you have to work, if the whole balance sheet, you're getting your liquidity problems on the top right corner of the balance sheet coming from solvency concerns, which is looking at the whole balance sheet, then our interventions have to do that as well. And we have categorized at the Yale program, for the new Bagehot project, these 20 different types of 20 different categories, subcategories of interventions based on where they appear in the balance sheet. At this conference, it's really this down at the bottom. You see restructuring in blue. Restructuring a resolution is a category RES, and stakeholder bail-in, which we have our BAIL, a very clever way of calling bail-in. So those are our categories there, and you'll see that the very thin white line is going through them, because restructuring isn't just on the asset side or the liability side of the balance sheet, but is kind of doing something to the entire balance sheet. Okay, and so we're going to look historically at all these various categories. Let me just tell you what the big ones are, right? I've talked about lending, that's in green on the right. That's the top part of the right-hand side of the balance sheet. Below that are capital injections. So one does not want to do capital injections without thinking about what that's going to do to the emergency lending you're doing. That's our nice purple. Going all the way over to the left-hand side, when we deal with the asset side of the balance sheet, that can be done in either ad hoc or broad-based ways. So either we're going to take the assets of some particular institution and figure out how to dispose of them. That's ad hoc asset management. Or broad-based, we'll set up some kind of fund overall to take the assets from a whole lot of failed institutions. So what are best practices from these different things? This is kind of our open question. In the middle are guarantees. And guarantees can be either on the asset side or the liability side. So it's not that we didn't know how to line up the tabs in that particular box, right? But you can have an asset guarantee just for the asset side. You can have an account guarantee or an extended account guarantee that would just be on the liability side. You can have a blanket guarantee that really goes and touches a lot of different things. All the way over on the right are some things that fit less neatly into the balance sheet, to the direct balance sheet structure. Those are, you can change rules about banks, or you can do other things such as some major forms of communication. Communication on its own, as taught to us by Mario Draghi, can often have a very large impact. Okay, so that's our overall structure. What do we do with that structure? Well, we started with a research project trying to identify historically how many of these things have there been. Up until COVID, we started this project a long time ago, well before COVID. Up until COVID, we got about 2,000 of these looking back through history. The vast majority of them in the last 200 years, but some of them going back further than that. There's a lot we can learn from that by looking at the details of what were done in various types of interventions. Mostly what you see are a lot of mistakes that you don't want to do again. Okay? It is not so much that we have some kind of wonderful plan and says this is exactly how you should fight every financial crisis, and just plug this into the computer and it'll tell you what to do. But we do have a lot of things that you shouldn't do. Okay? And it would be very nice if we could just avoid making the same mistakes over and over again. And so a lot of what we do is catalog that. But there's also a lot of cool and interesting things that have been done under duress by smart, creative people in rooms like the crisis room, I love that name, across the hall that we have here at the SRB. We need to have a crisis room at Yale now. I'm going to work on that as soon as I get back. And so we're going to try to catalog that. We've got about 2,000 of these things. By the way, during COVID, there were about 2,000 more. Okay, so things that look like interventions in financial crises that have the same flavor of them. They're lending, they're capital injections, they're rule changes. They look just like things in financial crises. We had about 2,000 of them done worldwide. We were cataloging them in real time during COVID. That's as many as we had in a couple thousand years of history before that, because pretty much every country did them around the same time. But you might think and note, but that wasn't a financial crisis. Okay, so why are you studying those things? And that's actually true overall, is that we study the things that happened in financial crises. Historically, we don't study any of the things that might have prevented them, okay, beforehand. So in our database, we tried to gather those as well. It's really funny. It's like you only study cases where the patient ended up in the hospital, not when we took treatments that kept the patient out of the hospital. So we're trying to study those from outside as well. Okay, this is what the knowledge hierarchy looks like and what it is that we're trying to do. At the lowest level, are lowest not in importance, but in terms of being a primary source, are what we call lessons learned interviews, where we interview people who worked on implementing specific interventions during crises, obviously a lot of these are GFC or things that happened no earlier than the 90s. And these are intended to just the subjective experience that someone had. We say, hey, what lessons did you learn? What would you tell somebody who had your job the next time about what to do? And we don't edit those except to just make sure we can understand the person's views. A lot of times people say, here is the lesson you should learn, and I think that is exactly wrong, but we leave it in, right? This is the subjective coming from the people who are actually involved. And if you're thinking, well, all crises are different, what can you learn from, some crisis a long time ago in some country that's very different with a different legal regime? It all seems quite different. That's a standard thing that people say to us. I will, without going into my very long discussion of why I think we can learn, just point out the example of we had extremely effective things that we did during COVID. We didn't have a financial crisis during COVID. Certainly when it started, I thought we were going to have financial crises. We did extremely effective things that looked quite good. The things that were most effective were off-the-shelf things that had been built during the global financial crisis. You can't really think of two crises or potential crises with farther apart in the cause spectrum than the GFC or COVID, but it was still kind of the same things that were the most effective. And that's because generally in a fire, we're going to pour water on it, right? And it doesn't matter what caused the fire so much. So there's a lot of stuff that you can mess up by not learning the lessons from the past because you think they don't necessarily really matter. So that's our lessons learned. The next level, level 2, we call case interventions. Those are cases about interventions. Aren't we clever in calling them case interventions? And for the case interventions, those are objective as opposed to subjective. This is where we spend most of our time and money and person time, which is we'll take a specific type of intervention that was, so we'll look at Banco Popular. So we'll look at Popular and we'll go and we'll study it and we'll say, here are the 14 key design decisions that had to be made when that particular resolution restructuring was going on. Here's the 14 types of things. What was the legal authority? Are you going to bail in? Et cetera, et cetera. And for an entire category of intervention, we will use the same key design decisions and go through them boom, 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 boom. And we'll write that up kind of in an objective, Wikipedia, neutral point of view way. Okay? At the next level, which are the surveys, we will look at about 25 of the case interventions, all of the lessons learned that go with it, and try to elicit some general rules, some do's and don'ts. Okay? We label things as like, this is a pretty interesting idea, or this might have been a mistake. Okay? And then at the very highest level, we're going to pull it together into some doctrinal documents. We haven't done that yet. Okay, we're waiting to be done. We've written, as you can see, all the way on the right, as of phase 2, 11 of the surveys, 292 of the case interventions, and 106 of the lessons learned. These all get published in our Journal of Financial Crises. All right, so what have we learned so far? I think I have approximately 5 minutes, and I've learned 4 things. So we'll see if I can, I'm just going to list them real quick. First is focus on the whole balance sheet. I've already talked about that. Okay, so rather than just thinking about this as, hey, let's set up a program in capital injections or let's set up a program in lending, you really have to think about how these things fit together. For example, we have learned that if you're going to do capital injections, you should probably do some form of guarantees at the same time. There's some deep reasons for that, but doing one or the other on their own is usually not the best way to have a multiplier effect. Okay, crises, this is an important one. Crises have 2 phases, acute and chronic. And interventions must be tailored for each phase. Okay, so there's a general sense of what acute means is, oh God, we're in a panic phase. Everyone's panicking, that's acute. But we can be a little more precise than that, which is that in an acute phase, you're facing runs, but when you're thinking about it as a policymaker, you're really focused on affecting the behavior of bank counterparties, not banks themselves, right? You're not thinking about like, oh, how can we get Citigroup to have the right incentives going forward? It's much more about how can we get people not to run on Citibank, things like that. And that's in the acute phase. In a chronic phase, you're much more worried about what the banks themselves will do. Are the banks going to start lending again? We have an undercapitalized banking sector. How can we get the banks to start behaving like banks again? Okay? And you need to tailor the types of programs that you have and the design of those programs for those two different phases. By way of example, I'll talk about TARP in the United States, the Troubled Asset Relief Program. That was a $700 billion program during the global financial crisis. It gave out half its money in the fall of 2008, which was a very acute time. In the United States, we were worried about the entire system collapsing, and we were worried about the counterparties of the banks. And it gave out, about half of its money was allocated towards what later became a chronic thing. It gave out a lot of that in the spring of 2009. And at that point, markets had stabilized, spreads had shrunk, but we were really concerned we would have a very deep recession because banks were undercapitalized. The way it gave that money out, by accident, I do not think by design, but by accident, largely worked out right. The communication of it did not. The way that they designed it is that in the acute phase, there wasn't that much concern about moral hazard. They kind of shoveled the money into the banks. Thinking too much about moral hazard in the acute phase is a great way to have a program that does nothing, okay? You won't have a moral hazard problem because you won't give out any money, all right? In the chronic phase, they did stress tests, they applied conditions, that was fine. Okay, because at that point, you really want to reinvigorate the banking system. You're not that worried about stigmatizing those who take the money, and that's not a concern that you're, and we go into great detail on this to try to separate those two things out. Now, they communicated this program terribly. This is going to be one of our next themes, which is when they started the acute phase program, they said, this is going to make banks lend more. And that had absolutely nothing to do with why they were giving out the money in the fall of 2008, and many people criticized them later for the banks didn't lend more. Okay, that was a communications error, which ended up using a lot of the scarce political capital that the United States government had to fight that crisis. And that brings me to 3, communication strategy is crucial. It is remarkable how often the program is, people come up with it, very complicated things, and then they just send somebody off to write the press stuff about the program. And lots of things get messed up at that particular stage. Right? Because the communications are just unclear, people don't know what you're doing. We notice a very common mistake is they had to walk something back. And because the first few days of the program are when you are affecting expectations, specifically during an acute period, you want to have the communication strategy wrapped up at the beginning. Now at the Federal Reserve, for example, I know they have a group that not only is designing plans, but writing the press release that will go with those plans when they come out. They do that way in advance, right? And then they'll just go fill other stuff in, and that's great. And that brings me to number 4, which is prepare in advance. We are at a place that is preparing in advance. This place did not exist in 2008. Okay, and those are the types of mistakes that we made often before the global financial crisis that we're starting to remedy. But it is crucial, particularly in an acute phase, that you can get programs all across the balance sheet up and running quickly. Okay, common mistake is, yeah, this took a month to get set up. A lot of times because people didn't properly consult their lawyers early enough in the process, and they did a whole bunch of things that turned out to be illegal before they actually set them up and sent them off into the world. So you really need to be prepared. The types of things done at the SRB are crucial, but we need to do them all across. The deposit authorities need to be ready for a wide variety of things. The coordination within countries and across countries. Now we're starting to practice it a little bit. We need to practice it a lot more. I'll end just on the note that it is truly remarkable. This is probably not something that we have at the SRB, because the SRB, this is by law, we're supposed to be thinking about getting prepared. But if you talk to central bankers, and I'll go to a room and like this, and I'll say, how many people in this room are working on preventing the next financial crisis? And all the hands go up, because why would they be at my talk otherwise? And then I'll say, how many people are working on what we will do if the financial crisis happens? And a couple of people will sheepishly put up their hands. Sheepishly, because admitting you're working on what you'll do if a crisis actually happens, of course, will foment that crisis, right? Oh, no, the Fed will do nothing if there is a crisis. That's the best way to have people, like, we're going to have a fire department, but we will not come to your house if your house is on fire, because that would cause moral hazard. Everyone will be setting fires in their house willy-nilly just for fun because they know the fire department is here. So there's a sense in which we can't talk about what we would do if a crisis actually happens, because then everyone will think, oh, well, they're here, I don't have to worry. But you just can't live that way, having seen that the crucial mistakes are not being ready and not being prepared. That's why I'm delighted to be here to talk to a lot of people who legally are required to be prepared and don't have to apologize for it. All right, I'm done. I'm maybe a minute late. I'm sorry. Thank you very much.
Thank you very much, Andrew, for such an interesting start to our discussions. And I'm very happy to say that Andrew is the guest on our next SRB podcast, so please keep an eye out for that. With that, let me introduce our first panel today, which focuses on resolution transfer tools, legal challenges, and the impact of digitalization. Our moderator, SRB board member Pedro Machado, will introduce the expert panel and get started. Thank you. Pedro.
Yes. Where am I? All set. So, good morning, everybody, and ladies and gentlemen, we welcome to this third edition of the Legal Conference. Let me just start with a word of praise for to Carl Philip, our General Counsel, and his legal team to be able to set up again this third legal conference, which is becoming anchored in the time of the legal circuit of conferences, and we hope really that it continues so for the future. So, and of course, thank you to our communications team for the support in preparing this conference. This panel, as it was already introduced by our chair, is going to deal with transfer tools and the impact of digitalization. So the issue might seem a bit awkward in terms when you read the title, but we will start from the perspective not only of what has been now very much topical in terms of discussing around transfer tools which go into this ambition to have more optionality to manage a crisis, a banking crisis, and for that we of course will delve into the sort of experiences from last year, from the spring of 23, both in the US but also here in Europe, not in the banking union, in Europe I mentioned, but and we will also stress an issue which maybe has a root in the financial crisis, but also might improve the way you manage financial crisis. And I'm talking about digitalization. As you know, banks have over the last years engaged in deep digital transformation agendas. It started in particular in the payment landscape and the improvements, especially with today, instant payments have been quite profound. But we are also seeing now, and we saw last year, how deposit outflows can quickly unfold with unprecedented and velocity that, of course, sometimes leave very few room for resolution authorities or for authorities to manage the crisis. And the digitalization today is also sort of channel of fueling crisis, and in particular to have an impact on financial stability. But at the same time, digitalization can improve the way we manage crisis, banking crisis, because it provides an array and a source of data that before we were not able to manage, and in that regard might prove to be quite a useful tool when it comes to executing in particular transfer tools, and I'm in particular referring to the management information capabilities of banks to set up all the platforms, all the VDRs that are necessary, the transaction documentation that is necessary to carry forward a transfer tool, in particular sale of business. So with this in mind, I'm very honored and pleased to be joined by this excellent group of panelists that were so kind to not only come here to Brussels, but also to prepare themselves to address this esteemed audience. And we'll go by order. I'll start by thanking Ben Stark, Deputy General Counsel of the FDIC, who is coming here to share with us the experience, the US experience, not only the US framework, which is very, as you know, it's very savvy in terms of how it has over the last decades executed and implemented transfer tools, but in particular to also shed a bit. We will have the privilege of having some insights on last year's crisis. Then we'll follow up with Monica Moniz-Lopez, or Lopez-Moniz, sorry, who is Global Head Supervisory and Regulatory Relations of Santander Group. Monica is in a privileged position to share with us some of the insights as having been from a banking group which purchased a banking resolution, namely Banco Popular. So I think it's going to be very interesting to get a bit acquainted with that experience of being on the side of the purchaser in the implementation of the sale of business. And then we'll follow up with João Freitas. He's the head of the resolution department of Bank of Portugal. And João is going to also share another experience, another very interesting experience, which has to do with the setup of Bridge Bank in resolution, which was the case of Banco Espírito Santo, and led to the creation of Novo Banco, which is up and there running and in Portugal. And finally, we'll end up with Seraine Grunwald from the University of St. Gallen, professor from the University of St. Gallen. And Seraine is going to bring us a more conceptual approach, in particular to bridge banks. And I think it will tie very well with the rest of the presentations that we're going to be delivered by the panelists. And then if we have time, we'll have some debates, some follow-up questions. And of course, the audience is also willing to most welcome to raise the hand and address any question or any comment which is deemed relevant, of course within the time frame, because here my colleagues are very draconian with the time, so we'll have to stick to that. So without further ado, Pan, if you want to start.
All right, thank you. Thank you all, the SRB, for welcoming me here. I know the staff at the FDIC and our chairman feel a very special bond with the SRB as a fellow resolution authority. So it's a great opportunity to be here and talk with you. That's probably all I should say before I note that the remarks I'm making today are my own and not necessarily consistent with the FDIC, its chairman, or its board of directors. But I did want to take the opportunity to spend a little time talking about what happened in the United States in March and April of 2023. It was an extraordinary time. At first, it's probably worth just walking through the insolvency regime. Pedro, I think you said it's savvy. I think convoluted might be another word. I would expect most of you working with us are probably most familiar with the Orderly Liquidation Authority that was created in Dodd-Frank in 2010. That had absolutely nothing whatsoever to do with the bank failures last year, and some people really question why. But the bank failures themselves were handled under the Federal Deposit Insurance Act that has been in existence, created the FDIC in 1933. It created us as a temporary agency. FDR was concerned about moral hazard, but things worked out. In 1934, we were made permanent, and ever since then have been ensuring the deposits of banks and being the resolution authority for banks in the United States. You know, we were very, very busy in 2008 and after that, and closing, I think we closed 500 banks and have spent a lot of time, all of our time since then, doing resolution planning so we would be prepared for the next crisis. And then on Thursday evening in March of 2023, I was called to a meeting to talk about a bank called Silicon Valley Bank, for which I had done no resolution planning whatsoever. I had barely ever heard of the bank. We were called into the chairman's conference room by the bank supervisors, and they said, "We've got a problem here. The rate that the deposits were fleeing this bank was unimaginable, and it looked like resolution was unavoidable." And we spent the night talking. We spent a lot of time talking to our colleagues at the central bank, at the Federal Reserve, trying to decide what to do. As I said, this bank in and of itself was not systemic, and so the plan from day one was to resolve it under the Federal Deposit Insurance Act. The primary guide for us under the what we call the FDIA was to limit the cost to the deposit insurance fund that the banks provide for, that the FDIC meters out. We have what's called a least cost test, which says if you want to sell the bank, you have to sell it in the way that it costs the fund the least, and that has to be less than it would be to liquidate the bank. And even though I didn't know much about SVB at the time, the appropriate resolution strategy was fairly clear. SVB's deposits were over 90% uninsured. So in a liquidation, the FDIC would only have been responsible for the insured deposits, and it would not have cost us that much. So we decided we would do a liquidation. We given the fact that the bank was over $100 billion in assets, it was a significant sized bank, we decided to liquidate under what we call a DINB, a Deposit Insurance National Bank, which just is a bank that will take over the insured deposits, and rather than the FDIC mailing checks and transactions being voided, it allows weeks or months for the deposits to be withdrawn. And it was Thursday night. I mean, it was well into Friday at that point, and we said, we really like to close banks on Friday night because that gives us all weekend to get organized, and particularly when you're going to focus on insured deposits, an insurance determination has to be made. We had conversations with the Federal Reserve and agreed that they would lend into the run, as they say, and that we would be able to keep the bank open all day Friday, and we would close it Friday night and get organized. So we wrapped up things about 4 o'clock in the morning. We had a plan. We felt pretty good. I went home. I got 2 hours sleep. I came back, and the Fed said, and I think this is part of digitalization. I don't know if this is the good part, but they said, we are now aware that the withdrawals planned at this bank on Friday are going to well exceed the amount of collateral they have available to place at the window. And that put us in a position of having to decide, would we want the Fed to lend? They are a secured lender. If they didn't have sufficient collateral, well, let's just say the FDIC has never paid the Fed anything less than fully what it's owed, and it would be somewhat unprecedented to do that. So at that point, we decided we could not close a bank on Friday night. It had to be closed right away. And the state of California, which was primary regulator, appointed us at 8:15 in the morning on Friday to be receiver of this bank. And we proceeded with liquidation. And let me be clear, at that time, the only thing on my mind was Silicon Valley Bank. And under the FDIA, we definitely had a plan that would have limited the losses to the deposit insurance fund from Silicon Valley Bank. We had not planned it, so we hadn't done an insurance determination. The bank more or less just stayed closed all day. The people's ATM cards were used, but the branches didn't open. And as we got ready to create this DINB and make deposit insurance payments available, we had another call from bank supervision people about 5 or 6 o'clock on Friday, which we've come to learn is if bank supervision calls you at 5 o'clock, it's a call you usually do not want to take. And we said, thanks for Silicon Valley. We think we've got this under control now. They said, we don't want to talk about Silicon Valley. We want to talk about Signature and First Republic. And I said, well, what the hell is Signature and First Republic? And of course, Signature was another $100 billion bank located in New York City. First Republic was a $200 billion bank located in California. And the bank supervisor said, Signature Bank will not be able to open on Monday. And they said, we're not feeling great about First Republic opening on Monday. And that gave us pause, right? I mean, we had, decided to liquidate on Friday night, then we had moved to liquidate on Friday morning, and now it was time for a third option. It became apparent that entering into a transaction that would cost the deposit insurance the least for the failure of Silicon Valley was not the appropriate thing to do. As I said, that's the general rule under the Federal Deposit Insurance Act. There's an exception to that that says you can look at other costs if there are systemic impacts to the failure. And it was clear that that's what we had to do. It was interesting. Many pundits suggested that Silicon Valley Bank wasn't large enough to be systemic. And they're absolutely correct. It was not. But while Silicon Valley Bank was not systemic, in this situation, the failure of Silicon Valley Bank was very much systemic, as it was causing deposit outflows certainly at Signature and First Republic, and frankly, many other large regional banks in the United States. And so the FDIA provides that in unusual circumstances, we can enter into transactions that are not most cost effective for the DIF in that particular transaction. It's a unique circumstance called the systemic risk exception. It was adopted with the least cost in 1991, and I remember thinking, nah, we're never going to use this. It requires a supermajority vote of the FDIC board, a supermajority vote of the Board of Governors, recommendation to the Secretary of the U.S. Treasury, and then she would talk to the President of the United States. And I thought in 1991, there's nothing that I do that's important enough for the President to know about. Well, it turns out, actually, we had done this several times in 2008, but it was clearly required here. And so the decision was made to protect all the deposits, as that term's used in the FDIA, which does not include deposits that are outside of the United States. Generally, all those deposits would be protected by the Deposit Insurance Fund. And we had a board meeting on Sunday, authorized the SRE, created two bridge banks, one for Silicon Valley and one for Signature Bank. It turned out that First Republic was able to open on Monday and got significant deposits from large banks in this country that allowed it the liquidity it needed to survive a little bit extra time. But we created the bridge banks, we moved all of the deposits into the bridge banks, and we operated them for a relatively short period of time. And I know, Peter, you want me to talk about bridge banks. In the U.S., there's really nothing easier than setting up a bridge bank. It's statutorily, I'm not sure how it's done. There's someone on my staff who takes care of it, and as long as she gets it done in a couple hours, which she always does, I'm fine. There's a process where we work with the comptroller, the chartering authority for national banks, and a new bank is created by basically snapping your fingers. So it's very easy to create a bridge bank. Operating a bridge bank is not as easy. It's a new entity. When the failing bank gets put into receivership, there's a transfer of all of its assets and deposits, depending on the transaction, to the bridge bank, which is a new national bank, which is authorized to do anything any other bank is authorized to do. But getting counterparties to do business with the bridge bank was troublesome. It's interesting. A lot of the transactions we had to engage in were with GSIBs, the largest banks in the country, and we were dealing with the mid-level managers of those banks who were thinking, I'm not sure what a bridge bank is. I'm not taking any chances. Fortunately, our bank supervision people know people at high levels at the GSIBs, and calls were made, and the transactions were freed up. But getting people to understand bridge banks and how they operate was very tricky, and we think going forward how we ought to, should we do seminars on bridge banks, and so everyone will understand. And of course, the thought is if we do, everyone will want to know, why are you talking about bridge banks? What's about to fail now? So we are holding back on that, but the educational process was difficult. So, selling and terminating the bridge banks were fairly easy, given the crisis mode and the fact that Bridge Bank is a nationalized bank, and in the United States they don't love to have the government running entities. The Bridge Bank for Signature only lasted a week, and we sold it. The Bridge Bank for Silicon Valley lasted 2 weeks. One of the reasons that they were so short was there were part of the franchises of those banks that were very difficult to maintain, in particular the wealth management business. And we had to sell the entire bank. As I said, we did very little resolution planning with these banks. Signature had never filed a resolution plan. The other two banks had filed plans, but resolution planning, as you know, is an iterative process, and we just hadn't done the work. Both of the banks, bridge banks, had wealth management businesses, which it was very hard to hold together. And without having done resolution planning, it really wasn't possible to sell separately. Yes, there's a separate wealth management subsidiary, but that also relates to deposits in the bank. And if we'd had a roadmap through a resolution plan, I believe we could have sold the wealth management businesses off, spent more time stabilizing the bridge banks. But we were able to sell both of them. We sold quite a bit of Silicon Valley in a P&A. We kept all the international stuff. Another regional bank bought it, didn't want it. That was a tremendous amount of work for the FDIC receiver compared to the part of the bank it made up. We sold, frankly, very little of Signature Bank. We kept almost all the assets, managed them ourselves, and sold them off separately down the road. So I think I've probably gone well over time, but if you take anything away from this, it's the critical importance of resolution planning. The FDIC works with the Federal Reserve, planning for financial stability issues with large banks. We have our own regulation on dealing with smaller relatively smaller banks that we're in the process of updating. And given the speed of these failures, the Resolution Authority, I think, has no chance without having significant resolution planning and getting ready to go. So.
Thank you very much, Ben. It was very encouraging hearing you about the importance on resolution planning, and maybe, if I may add, also loss absorption capacity by the system. So I think this ties very well with then but it also sounded, let me just add that, very familiar, and maybe João is also going to tell about that, how challenging it is to operate a bridge bank. It's really
right.
challenging, but I think he might have a lot of insights on that. But since one of the things that has to do with talking about this with transfer tools is that first and foremost, any resolution authority will try to sell a bank if the resolution strategy, if be preferred, be variant, you will try to execute over the weekend a resolution, a sale of business or an assets deal to basically handle the crisis cases. In the case of Monica and the group, you didn't have the luxury of having a weekend. So it was a night, and you can tell a bit about us, about how it was to be on the side of the purchaser in the sale of business.
Okay, thank you very much. I would like to start by thanking the SRB for inviting me to this legal conference, and also Pedro for chairing and organizing this panel. So thank you very much. So I think after the experience gained in the Banco Popular case, I mean, it's been a while since it happened, 2017. It was said this morning, today and tomorrow will be the 7th anniversary. And it looks like yesterday, but I think what I would like to say is that we've come a long way. And today, probably the things that we will do would be different from what we did back then. And then, of course, we've learned a lot from that experience. But I think, as Dominic pointed out this morning, there's a general message that I think we should never forget, and that is that resolution authorities need to count with actionable and flexible tools in order to address the resolution. And that's why it is so important to have an adequate legal environment and framework to be able to ensure the good end of the resolution action. And also in a crisis scenario, it's very important to be able to take decisions as quickly as you can to prevent the banking resolution from further deteriorating, especially in a time like today where with digitization, I mean, the run of deposits can be very quickly because customers can easily and quickly take out their funds. So if we look back, I think that in the experience that we've gained in the recent years, probably the sale of business tool, I would say, is one of the most straightforward and direct tools that you can use, and it probably implies less complexities than other transfer tools that you can think of, or even the bail-in tool on its own. But again, the sale of business has some problems. I would say, first of all, market appetite is never perpetual, and normally these resolution cases occur in times where there is financial instability that affect the whole banking sector. Second, the feasibility of this tool depends very much on the size of the bank, and normally the sale of business is very limited at a national level, and that is always an issue. So I would say that this tool probably on its own does not seem the one that you would use in case of a GSIB or other systemic institution. Just for small and medium banks, like it happened in the Popular case, that I think probably marked the limit in terms of balance sheet size in order to apply and to use this tool. But again, this case, as the Great Swiss case last year, they show the need to improve this tool in the future, so that in case of a crisis it can be used in an agile manner and make the sale of business attractive to other banks. So with the experience that we gained from the Banco Popular case, I would say that of course we need a more specific regime for the acquisition of banks in resolution in place, and in the different stages of the resolution process. So first of all, for the run-up in resolution, I think that it's very important, and it was also highlighted this morning, to have a very clear communication strategy. I would say that is of the essence to avoid, of course, an acceleration of the crisis. But not only thinking about the resolution authorities that should, of course, develop a clear communication strategy. I think that's very important to avoid any leaks or any public statements that could lead to a misinterpretation and accelerating even the resolution process. And then also from the entity in resolution side, it's very important to develop this communication strategy, avoiding contradictory messages, as you recall happened before the acquisition of Banco Popular, and that accelerated even the exit of deposits. And also from the acquirer entity side, it's very important to have a coordinated communication strategy with the resolution authorities. And I think this is something that has improved a lot in the past few years. We, all banks, of course, in coordination with the SRB, have been working very heavily on developing these communication strategies. And it's very relevant, as Andrew pointed out this morning, not to have those strategies in place, but also to test them and have them ready just in case you need to use them. So it's not thinking about what would I communicate, but writing the things that you would communicate and having them ready for all the possible scenarios that can occur. So for the resolution we can face, I think that where you need to make a lot of decisions without having real time to evaluate the effects of these decisions. It's also very relevant to have all relevant authorizations streamlined. That did not happen in the Banco Popular case. I mean, we got all the authorizations on the same day, except for the European competition authorization, which took 2 months, and that was a little bit of an issue because, of course, there were a lot of things that we couldn't do on the first days. We had to wait until we got those authorizations, and that was an issue. And then I think that we should try and encourage cross-border sales, because this is something that we are not seeing happening in the European Union, because that would, of course, increase the range of potential buyers in case of a crisis. As you know, we haven't seen major cross-border integration or consolidation efforts across Europe, mainly probably due to the market fragmentation that we still have and the complexities of a cross-border integration. I mean, Dominic asked today, do you understand the title of the conference? Of course, when we speak about navigating legal frontiers, it means that we are all very much aware that there are still these legal issues that hinder cross-border integrations. I mean, there's even, I would say, some room for further consolidation in most of the European countries at a local level. But I think that if we are one day able to achieve a full banking union, then we might see more cases of cross-border mergers, which we haven't seen today. And then I would also like to focus on the post-resolution phase, where we faced a lot of issues. Of course, we suffered, as you know, a lot of demands, litigations, lawsuits, negative social opinions, and we had to face numerous compensations. I was reading this morning an article in a Spanish newspaper speaking about the anniversary of the acquisition of Banco Popular, and it's interesting because from our side, and we've heard it this morning, we thought it was a positive experience, and we always talk about it as a case of success. But the article talked about the ill fate, or it said aciago in Spanish, you know, which is the dark day. So the public opinion in Spain, they thought about this transaction as a bad thing, you know, as a negative thing. While in our case, we always thought it was a positive experience, and that's why it is important to try and manage communication better. As you know, there were a lot of articles saying that we had acquired the bank for €1. Of course, probably that was literally something you could say, but I mean, the message was not really well conveyed, I think, to the public opinion. And the thing, as I was saying, is that it would be important having a system that limits the responsibility of the acquirer in terms of these lawsuits and litigations coming from the entity in resolution, because as you all know, in this type of acquisitions, detailed due diligence is not feasible, and therefore you need to acquire the entity without really knowing, in many cases, what you are acquiring. So that would reduce the lawsuits. And I would just like to give you some numbers, because, I mean, after 7 years, we have received more than 25,000 lawsuits against the bank, coming from clients and or non-clients from Banco Popular that held instruments that were affected by the resolution. And still 8,000 of those are pending to be closed. So this is something that we still will be dealing with for a number of years. And the total amount that has been claimed so far, it's over 1.30 billion euros. And it's interesting because I was looking at the notice that was published by the SRB in 2018, the notice of the Single Resolution Board that was published in August. And here the valuer, the Deloitte at the time, if you recall, estimated the value of the legal contingencies to either 1.79 billion in the best case scenario and 3.45 billion in the worst case scenario. So that was, quite, I mean, they had the numbers right, and that is something that I think should be solved for this type of sales of business tool. And then, in addition to that, there have been around 27 procedures coming from directors of Banco Popular, and the total claimed amount by these directors has been over 5 million euros. And some of these, as you know, are not even closed yet. And this has consequences that go beyond the acquisition of the bank. For example, in terms of the score that we receive for operational risk as a systemic bank in the SRB methodology, it has a big impact because we have so many legacy issues stemming from the Banco Popular acquisition, that we always have difficulties, in keeping a good score in terms of the operational losses that we have. So, as I said, it would be worth considering the possibility of limiting the criminal and the public responsibility for the mismanagement of the bank acquired. And this had also implications that maybe we never think about. For example, talking about internal models, that those banks in Europe that use IRB models in terms of instead of a standardized models, as it is the case in the US, this has a lot of implications, because if you cannot apply your models to the portfolios of the bank that you acquired, this means that you need to go through another internal model investigation for the models of Banco Popular, and then a different one from the models of Santander, and that takes a long time, because as you know, one internal model investigation can take more than 1 year, and this is something that I think should also be solved for these type of cases. And also, we faced a lot of issues with customer due diligence of the clients of Banco Popular. If you recall, all banks in Europe had to go through a customer due diligence process that had to end by 2015, by which they had to identify all the clients. In many cases, like in Spain, if you did not have had an updated identification for all your clients, you needed to make sure that that was updated. So all banks in Spain, we went through a really expensive and difficult process, and Santander had gone through that when we acquired Banco Popular, but Banco Popular hadn't done that. And it was really something that the AML authorities hadn't fined Banco Popular for that, and we had to go through the whole customer due diligence process again for almost 4 million clients coming from Banco Popular. So there are a lot of little details from a legal perspective that I think could be solved in order to make this sale of business tool more attractive. And then, as I said, this is something that has to be done in a coordinated manner between regulators, supervisors, and also the resolution authorities, in order to ensure that we have a framework that allows for this sale of business tool to be well applied. But I think that also from recent banking crisis, what we've learned is that the traditional 4 resolution tools that we always speak about probably are not enough on an isolated basis to resolve a bank. And I think that also the next step would be to continue working on combined resolution strategies in order to give the resolution authorities the necessary flexibility and room of maneuver which is needed to adapt each resolution bank to the different situation. And in this regard, as you know, banks in Europe have been working very hard on the operationalization of the bail-in tool. But if we consider that today, with the digitization and the cyber threats that we have, and the fact that bank runs can be prompted, by a deficient communication strategy, I think that the SRB should count with the necessary flexibility in order to apply the most efficient resolution strategy. And that's why we believe we should be focused very much on working on this operationalization of the combined resolution strategies. Sorry, because this word operationalization is something, I don't know, it's so difficult to pronounce, I always try, but it's like almost impossible. So it's true that it's very important also if we try and leverage on the review of the BRRD and make sure that we include all these combined resolution strategies, because it's important to define the type of strategy bank by bank, but then for large banks, probably we should consider combining the bail-in tool with the sale of business tool. And that's why it is so important that banks have already undertaken the work of preparing the separability analysis report. For example, in the case of Santander, as you know, we are an NPE resolution strategy bank, which means we have different points of entry, and we have developed the 11 separability analysis reports for our 11 points of resolution or points of entry. And that is very important, because it means that whenever needed, you could, in a very straightforward manner, separate one of the entities, without having to go through a difficult and cumbersome process. So I think that's also very relevant. And then I also would like to mention that we very very much welcome the consultation that the SRB published on the MREL policy, because also we believe it's important to consider in the calibration of MREL these combined strategies that I was just speaking about, because that would allow to adapt also the MREL requirements to wider optionality in terms of resolution tools. And also, of course, this is something which is very important, but I would like to stress very much that the implementation of this combined resolution strategies should be done in a gradual manner, because already banks have spent a lot of time and resources in the operationalization of the bail-in tools, so this is something that should be done gradually. Maybe I would stop here, and probably we have some time later on to speak about the digitization issues, which is also something we wanted to consider. Thank you.
Thank you very much, Monica. I think Monica gave a good insight about what are the challenges in particular, not only, implementing or executing the sale, but in particular on the post-sale moment. And the issue on contingencies, we know well how it can be very challenging in addressing after the resolution scheme has been it's adopted and implemented over the weekend. But maybe here, I think also João has a lot to tell on this, on the bridge bank, so I'll pass over to you, João, to tell us a bit your experience with the bridge bank.
Okay. Thank you, first of all, Pedro and the SRB for the invitation. I think that both Andrew and Pen mentioned that it's perhaps sometimes difficult to speak about how we are preparing for a possible crisis, because it can create an alarm. But I think that these events do a lot to address the stigma and to show that it's okay and it's normal to be prepared and to be able to act when necessary. It shouldn't be a cause for alarm. I will try to leverage on our experience. Of course, it's always useful to speak about your traumas, so I thought I could use that experience to share with you some thoughts. And just as an introduction and background, we have actually implemented different transfer tools in Portugal, not only the Bridge Bank tool, which was used in the case of Banco Espírito Santo in 2014, 10 years ago, by the way. But a year later, we used the sale of business tool as well to sell Banif, also to Santander, by the way. So Santander is more than one experience in acquiring banks in resolution. And at the time, we also created an asset management vehicle. But of course, the Bridge Bank was perhaps the most between these two cases was the most distinguishing case, because, well, it was extremely complex. BES at the time was a bank which was quite large for Portugal. It was the total assets of BES were 8 billion, which is not much if you think about the American environment. But for Portugal, this was 50% of Portuguese GDP. There was no loss absorbing capacity at the bank. Again, this was 10 years ago. There was no MREL, obviously, at the time. And when the bank failed, also there was no buyer. No appetite, no conditions to have a buyer. And so it was extremely complex for all these reasons. So we did go for the Bridge Bank at the time. We created Novo Banco, which, as you mentioned, 10 years after is a profitable business and is appropriately capitalized and doing good at the moment. So if we move to the next slide, I would say that it's, and this is probably the first idea that I would like to convey and it should be clear in my view, is that I think we all know and agree that the Bridge Bank is not the tool that you would want to use in resolution. It's a temporary tool, obviously, so we would still need to sell the bank. It's definitely, or it can be fragile in preserving confidence and also in maintaining long-term commercial relationships with clients or counterparties, obviously, for the reason that it's a temporary solution. So for this reason, it can erode the business. And it does require hands-on control by the resolution authority after the bank is created. So it's true that it's fairly easy to create the bridge institution. This was created by a decision of the board of Banco de Portugal in the late hours of a night in August. But afterwards, it took a lot. So the resolution authority continues to be in control of the bridge institution, and in our case, this happened during 3 years. So the bridge bank was under the control of the resolution authority for 3 years, and it's quite burdensome and troubling. So definitely not the tool you want to use, but the point is that it's a tool that you need to be able to use. So you want to have this option available if necessary as a fallback solution. If you compare it to the sale of business, first of all, it's obviously also very effective in terms of ensuring continuity of the business of this failed institution. And it's obviously the solution that you want to have if you were trying to sell the bank, but you don't find a buyer. At the time, as I said, we also wanted to, or would have preferred to sell Banco Espírito Santo immediately, but this was not possible. And so with a bridge bank, you're actually dependent only on your decisions. You don't need to find a private investor to execute the resolution tool. And also, the reality is that you, as I said before, you will eventually sell the bank, but with a bridge bank, you gain some time and you might be able to sell the bank in a different environment, perhaps with better terms. The buyer might have some time to execute a due diligence, which, as mentioned before, is not possible in an outright sale of business. So there are advantages also compared to the sale of business. Again, not saying that it's preferred to the sale of business, definitely not, but there are some advantages. And actually also compared to the open bank bail-in, it might be more effective in stabilizing the bank. So it's not entirely clear to me for now how effective the open bank bail-in might be in stabilizing an institution post-resolution. I mean, it's after you convert bondholders into shareholders, how effective that might be in preserving confidence on the bank, for example. The bridge institution is also not great in doing that because, again, it's a temporary solution, but at least it's under the control of the resolution authority, perhaps more effective. And the other positive aspect in relation to the open bank bail-in, it's probably more effective in addressing contingent liabilities and litigation than the open bank bail-in. So what we did in the case of BESH is that we created this new institution and we left behind in the failed bank the liabilities that we thought would be problematic going forward, were not valuable, could be a burden for the bank going forward, and they were left behind in the failed institution. And the fact that you have a legal entity, which is the failed institution, still there, might be very effective in ring-fencing these contingencies. And of course, it does provide optionality. So even when you don't intend to use and you think you will not need the bridge institution, you want to have this fallback solution because you never know. You need to be flexible. And also because you don't want to negotiate with a potential buyer. You don't want to negotiate the terms and conditions of a sale with Santander, for example, without a fallback, without an alternative. And it's not a criticism, of course, to Santander. This is true for any bank. You don't want to negotiate the terms of a sale when you're refugee to that solution, obviously. So as a fallback, having it there is also positive. So the message here would be not the first best, definitely, we all agree, but still, we should not think that we should overlook the bridge bank. It is definitely a useful tool as a fallback solution. So it's full of challenges, and if we move to the next slide, I will not address all these challenges. I'll try to select those which perhaps are more relevant for a legal conference. And so in terms of licensing, now moving to the next slide, please. In terms of licensing, again, as I said before, implementing the bridge bank depends on the resolution authority only, not in don't need to find the buyer. But by the way, you still are dependent on a third party, in this case, the supervisor. The supervisor needs to authorize the bridge institution, and it will need to set the capital requirements of the bridge bank as well. And so there's a possibility for some misalignment. In our cases, we did feel this problem, let's say. I can share because this is public information, but when we resolved Banif and sold Banif to Santander, we were trying to have the bridge institution as a fallback solution, but realized that the supervisory authority at the time would not authorize the bridge institution, and therefore we didn't have the option available. Or when we tried to sell Novo Banco as a bridge institution at the time, the capital requirements were not entirely clear, and the bank was still undergoing stress tests conducted by the supervisor. So these issues, of course, are very relevant when you have to execute these tools. And so it is crucial that you, of course, keep a good cooperation, obviously, with the supervisor, and that all things are prepared in advance and discussed. What are the requirements for licensing of the bridge bank? Perhaps, by the way, they should be adapted from the normal requirements of creating a bank, of licensing a bank, because extreme circumstances probably do recommend extreme measures as well. And of course, it's an administrative process between two public authorities, so probably you shouldn't follow the normal procedure for licensing, but in any case, this should be prepared. So I think Pedro, we will still continue to discuss a lot in the coming years in your future role as well because of this. So in terms of recognition, this was addressed by Penn as well. Even when you have the bank up and running, there's an issue of recognition indeed. So we had problems. We had critical service providers of the bank coming to us saying that they were providing services to BES. They don't know what Novo Banco is. Novo Banco is not their client. So they were threatening to stop certain services or to revise the terms and the pricing of the fees of their services. Of course, this took a lot of work. We had to explain to them the legal environment, that indeed Novo Banco is a new client and they have to respect the agreements just as before with Novo Banco. It takes a lot of work indeed, and also making sure that the discussion, for example, the bank at the time had subsidiaries abroad, and so the subsidiaries, there's a new qualifying shareholders of this subsidiaries. It's no longer BES, it's now Novo Banco, and so you probably need to go through all the licensing processes as well, and the qualified shareholding processes with the the foreign authorities as well. And we did that process, for example, with the American authorities because of subsidiaries that BES has in the United States. We had to engage in discussions with them. We had to go through the full procedures of recognizing Novo Banco as a shareholder of these subsidiaries in the United States. So a lot of work also to be done in terms of recognition. The other two topics that I selected as challenges are in the next slide. Again, it's easy to create the bank and to define what are the assets and liabilities that are transferred to this bank. Well, and when I say it's easy, I'm of course exaggerating because it requires work in terms of selecting what assets are worth being transferred and valuable. But in any case, to execute this, you draft a decision by the resolution authority. You do this using general criteria. Of course, you don't go, at least in our case, probably in the future if you're very well prepared in advance, but in principle, you define the set of criteria to define the assets and liabilities that are transferred to the bridge institution, but then it takes time to execute, and there are many situations which are not as evident whether they were transferred or not, and so this takes a lot of work as well to implement the perimeter, as we call it. There's another issue is that, of course, we all know that it's the resolution authority who is competent to define this perimeter. But in the end, all these decisions are subject to judicial scrutiny. So a court might decide differently. There's the risk. And in this case, someone has to carry the risk. In our case, because this was a bridge bank, it was impossible for the bridge bank to carry the risk that a court could change the perimeter that had been set by the resolution authority. Otherwise, the bank itself would have to book provisions, and again, it would be suffering from the same problems it had in the past. And so the solution that, in our view, is more effective in addressing this is to use a resolution financing arrangement to provide assurance to the perimeter that has been decided by the resolution authority. So the resolution authority says that the assets and liabilities that have been transferred are these set of assets and liabilities. Of course, a court can decide otherwise, but this cannot penalize the future of the business. Otherwise, your decision initially was not effective from a financial perspective. So the resolution financing arrangement has an important role to play here. Before I understand that we need to probably to move on, but in terms of the last topic, contingent liabilities, I think it's we could perhaps have a full morning to discuss contingent liabilities and how to address them in resolution, honestly. Contingent liabilities might be so-called unknown knowns, in the sense that there are, for example, issues there or problems in the bank which are not yet full claims on the bank, but might materialize as claims. But they can also be unknown unknowns, in the sense that issues that come up only after resolution and might be transformed into claims on the bridge institution or on the acquirer. We think that, again, the bridge bank might be more effective in dealing with these contingent liabilities, because, again, there's an illegal entity that continues to exist, which is a failed bank, which goes into liquidation and to where these contingent liabilities stay. But of course, again, there's, in our view, also a role to play by the financing arrangement in this case. Otherwise, the business of the bank post-resolution will continue to be penalized by these uncertainty of contingent liabilities. And of course, when you create a bridge bank and you're trying to sell the bank, the buyer, I mean, you will not sell the bank to a charity, of course, and the buyer knows that there is uncertainty and contingencies looming on the horizon, and the buyer will probably ask some sort of assurance from you. Of course, you could, in theory, say that, well, I will consider these liabilities when I do the write-down initially, but you don't actually know how much these contingent liabilities might be worth, and it's very difficult to write down or to bail in certain bondholders without knowing the full amount of these contingent liabilities. So this is a difficult issue. Again, we could probably spend a full morning or more discussing this. The point I would like to make is that bridge bank might be a bit more effective on addressing this, and the resolution financing arrangement might do a lot in terms of dealing efficiently with these contingent liabilities. Thank you, Pedro.
Thank you very much, João. It's fascinating here to you. I don't know why it sounds so familiar, but well, 10 years ago. I just mentioned one thing on the recognition. The issue on recognition is a very interesting one when it comes to the bridge bank. Not only from what you said in terms of the market recognition from the market participant. Remember the discussions around the ISDA and the recognition for the purpose of ISDA, but there is also an issue related to contingent liabilities, and we have never to forget there is resolution in the law and there is resolution in the courts. And it's not always evident that the courts will fully recognize what are the decisions taken by a resolution authority. And you just have to refer to the interesting case law that is piling up in the European Court of Justice on some preliminary references, particularly coming from the Supreme Court in Spain, where you are basically dealing with this sort of recognition that has to do with litigation and contingent liabilities. But I think this sets well the scene for Seraina to conceptually analyze from your experience and also your expertise the bridge banks. Thank you.
Thank you very much, Pedro. Thank you to the organizers for having me here, for setting up this wonderful occasion to discuss transfer tools and other legal challenges or legal frontiers that we are facing. So I will also focus my intervention on bridge institution tools, and I'll try to complement my fellow panelists with a more academic perspective, but you will hear me echo many of the arguments that have already been put on the table. I think one or maybe even the central claim of my intervention will be that here in Europe we have paid too little attention to the bridge institution tools so far, and I hope that I will be able to convince you that there are good reasons for this to change. Now, if we look at the SRB's resolution planning, and Dominique has already said that this morning, bail-in is of course the key preferred resolution strategy. Sale of business is with 16 cases out of 88 is sort of the second choice of preferred resolution tools, and then we have the bridge institution tool as a variant, often, as it says, to the sale of business, but then in combination with bail-in. Now, this is true for significant institutions. If we look at least at the numbers of the publicly available numbers on less significant institutions, there we can see that in a very few cases, the bridge institution tool is indeed the preferred strategy for resolution. So if we take this resolution planning of the Single Resolution Board, we can identify a first use case, and that is the case if no suitable buyer is readily available that would take over the business of the failed bank, then we would choose to use a bridge institution. Now that begs, of course, the question, when is a buyer suitable? And how is the resolution authority to assess the suitability of a buyer? And interestingly, the resolution framework is rather unspecific on that issue and gives, of course, resolution authority broad margin of discretion on assessing that suitability. Now, first, the resolution authority must choose the resolution tool or resolution tools that best achieve the resolution objective. So if the only available buyer, for example, is itself in financial difficulty, then obviously the sale of business tool will not be the tool of choice. In the SRB resolution decision on the Banco Popular case, we read the following statement, and I'm going to read it out to you about why the sale of business tool was chosen and not the bridge institution tool. It says, given that the bridge institution aims to maintain access to critical functions and sell the institution with a time frame of, in principle, 2 years, and to the extent that the sale of business tool achieves the same result within a shorter time frame, the sale of business tool is considered to achieve the resolution objectives more effectively than the bridge institution tool. Well, that's not a particularly surprising statement. It doesn't elaborate further on the suitability of Santander as a buyer, which I do not want to question at all, by the way, but it is sort of implicitly assumed in that statement. Then we see we have a second legal stricture subject to exceptions, and that's the marketing requirement, the requirement for resolution authorities to market the assets, liabilities, instruments that it intends to transfer with a view to generating an offer that maximizes as far as possible the sale price. So the idea here is, of course, that the most suitable buyer is the buyer that offers the highest sale price. Now, we've heard before, the market for failing back is not a particularly competitive one. There is ways to improve that. One way would be to increase cross-border sales options. Another one would be, and I would very much side with Joao on that, would be to create a truly credible and feasible scenario in which we could use the bridge institution tool. That would add a competitive element here in the bidding. Then, of course, there is competition law requirements that I don't want to leave unmentioned. Here in Europe, they're quite important. So merger control would ensure that there's no significant impediments to effective competition. However, competition authorities, if they see such significant impediments, they would typically opt to impose conditions to sort of mitigate these impediments rather than really question the suitability of a buyer altogether. So the broader point I think that I'm trying to make here is that if we'd operationalized the bridge institution tool as a truly feasible alternative to the sale of a business tool, then the suitability of buyers could be assessed differently and potentially more stringently. Now, there is one aspect, in fact, that is not part of the assessment, and I want to point this out also because we obviously have big discussions on that in Switzerland, and that is the long-term concern of creating bigger banks. And that brings me to my second use case, based on what we've seen happening in resolution practice. So we're moving now from planning to actual practice. And here it has been mentioned before, bail-in, even though it was planned for, was not the tool of choice. We saw sale of business happen with, Banco Popular as a point in case, Sberbank another one, and then, of course, Credit Suisse more recently. Then one lesson that we are trying to take away from that experience is that we are trying to conduct resolution planning more flexibly in order to better tackle different crisis scenario, and we are trying to achieve or work towards more of a toolbox approach that is gaining traction. And I would like to echo here again, Joao, the bridge institution tool will play a part in that toolbox as well. Now, first you can think of combinations of tools that rely on the bridge institution as a primary tool. Joao has mentioned mostly the option of it being a variant. So you could think of a combined use of bridge institution with bail-in and or asset separations. Now, we have seen the bridge institution tool used together with bail-in in the past, in the Polish case, PBS, in the two Andelskassen cases resolved by the Danish resolution authorities, both or all three relatively small banks. But my claim would be that if we get the design of bridge institutions right, then this option might also be considered for larger banks. But of course, in most cases, when we deal with larger banks, bail-in will remain sort of the preferred primary tool, but then in combination with sale of business, with asset separations if necessary. And here again, if no buyer would be readily available to take over the assets that are planned to be transferred, then for a short period of time, a bridge could take these assets over. Now, very briefly, because I want to leave some time for the discussion, and Joao has already mentioned several relevant design variables when we try to operationalize the bridge institution. Now, this is less of a design variable, but just the reminder that obviously the resolution authority will have to decide what is transferred, right, to the bridge institution. Here as well, the legal framework is rather unspecific, or gives a lot of flexibility to the resolution authority to make that decision. I think I'm going to skip the question of capital requirements because João has covered that. Just briefly raising the question of how do we provide the necessary capital, by whom or from whom does that capitalization come? And here, we have the three options: bail-in, of course, in a broad sense, including the conversion of capital instruments, the resolution fund right after the 8% TLOF requirement, and finally DGS, where the CMDI proposal will hopefully bring some facilitation of the use of DGSs for transfer strategies and in particular for transfers to bridge institutions. Now, I would like to highlight one further point, and that's ownership and control. Now, in its current version, the BRRD requires that bridge institutions are wholly or partially owned by one or more public authorities, which may include the resolution authority or the resolution financing arrangement. And it says, however, also that it is in any case the resolution authority that controls the bridge institution. So there is a distinction that the BRRD makes between ownership and control. Now, if we look at the CMDI proposal, the proposal will waive the requirement for partial public ownership in case all the capital of the bridge institution is provided by conversion of bail-inable liabilities into shares of the bridge institution. And at the same time, it says that the application of the bail-in tool for the purpose of recapitalizing a bridge institution shall not interfere with the ability of the resolution authority to control the bridge institution. So, the question that arises is, of course, what is then the role of the owner? Or does it matter at all who the owner is? Now, simply put, obviously the owners are those that have the titles of ownership in their balance sheet. Hence, there will be those that bear potential losses and those that participate in potential gains. The second point where potentially ownership could matter is as a signal to the market. The market may see it as an advantage if public authorities have skin in the game, as a signal that they have a stronger incentive to optimize the sale price, and vice versa. The authority that is responsible for licensing and prudential supervision, often the ECB, but it could be national supervisors as well, should not be the owner. That's particularly relevant in those member states where the resolution authority and the supervisory authority are the same institution, because that could create conflicts of interest. So that would be ownership. And then we have control. What does control entail? Here, the BRRD mentions two main means through which resolution authorities gain control and maintain control. And that is, first, that it is the resolution authority that appoints the management body of the bridge institution. Clearly, that will be key. Also in terms of preparation, that there's a pool of people potentially available with the necessary skill set, with the necessary capacity and willingness to do that job, often with concerns about their personal liability. And then secondly, the BRRD says that the resolution authority approves the strategy and risk profile of the bridge institution. So obviously, management decisions regarding the operation of bridge institutions will have to be approved by the resolution authority. So in a process that would be ongoing through the through the entire lifespan of the bridge. A final point. It has been mentioned several times that the setting up of a bridge institution is an easy thing to do. That might be the case in the US. Apparently, it is the case in Portugal, but I would claim that there is a couple of member states where this is not necessarily the case. And so there's some participating member states that have been working on establishing shell bridge institutions. In Germany, for example, the Resolution Act empowers BaFin to set up a bridge institution in advance, a so-called Vorratsinstitut, and a similar regime applies in Austria. And I would think that within the SRM, that establishment of shell bridges really has the advantage that at least with these intricate national procedures, you would not have to deal ad hoc, and that many of the thorny, design features, governance aspects would be sort of dealt with in advance. And I would leave it at that. And thank you for your attention.
Thank you very much, Raina. And indeed, I think the picture here in setting up a bridge institution is not as straightforward as in the US, in the banking union at least. Since we have just 10 minutes left, I would propose that I'm going to bundle here 2 or 3 aspects that have been highlighted and touched by our panelists for a short round of comments. I retained from the interventions issues that had to do with the value of the franchise to stabilize. It can be both for bridge banks. I think one interesting feature that Monica brought was also to which extent when you acquire a bank that is perceived as having been more risky, to which extent apart from the impact on SREP eventually, but also whether this could or not affect the franchise of the acquiring bank, and to which extent it would be a dissuading factor for potential purchases. And then the issue that has to do with more, we already a bit of flexibility, optionality, a sort of combination of tools, to which extent this would make sense. And finally, if you have any ideas on digitalization as eventually also fueling or making the transfer tools sort of also more operationally viable, we could also touch upon this. So I would, by the same order, start again with Ben, just to have your comments, and we do by the same order, follow the same order, please.
Yeah, it's interesting with bridge banks in the United States. The option is that the bank is closed and placed into a bridge bank. So effectively, as Jel said, you have a good bank and a bad bank. You can make transfers to the bridge or not. The statute in the United States does not require that there be any capital in the bridge bank. The notion is that the FDIC Deposit Insurance Fund will back it, and everyone will be paid. This statute is important. The market really dictates things. So there may be a need to hold liabilities back. Certainly, I think the primary goal in resolution is optionality, to have the options you need. We are working in the United States to have debt issued by medium-sized banks that and I think our bail-in is primarily closed bank bail-in, and either the sale of the bank or placed into a bridge bank and have the debt left behind in the receivership. But one of the options that we would have is by creating a bridge bank, we would not necessarily have to have it result in a sale. There's, I think, 2 options. One would be to break the bridge bank up and sell it in pieces, which would have an impact on concentration and competition, which could be helpful. Or potentially, particularly with the bail-inable debt, if that's left behind, the bridge can be recapitalized and potentially, possibly downsized during the stabilization period, but potentially relaunched as a bank on its own, and maintaining the same amount of competitors. So I think the bridge bank provides a lot of options that can be very helpful. In addition to the notion that when a bank fails without any notice and there's no time for due diligence, it's important to just maintain the franchise value until a buyer can be found.
And Monica, if you would have, let's say, more granular access to, let's say, data, would you be considering that this would be fueling or making more viable sort of a sale in a resolution? Because the time to execute the transaction is quite short, not to say in your case it was one night, so due diligence is quite short. What could be the role of digitalization play here in terms of enhancing the availability of data?
Yeah, I think it could be beneficial indeed. I mean, we always think about digitalization as being a disadvantage because, I mean, clients can quickly and easily move their funds, which is, I mean, not exactly like that, because corporates can probably easily move their funds. Retail customers, they always have some limits, so you still can control that a little bit. I mean, it's not like when you had, I don't know, 20 years ago, the queues in front of the branches before they opened, but even today that deposit run cannot be achieved as fast as we always think. But and as I said before, if you have developed a good communication strategy, you can control that a little bit. But in terms of the access to data, I think that probably today the situation will be much better than what we had in 2017, because we would have better access to data. I think that, as you said in the beginning, with management information systems, we have really come a long way, and probably this access to data will enable the possibility of not undertaking, I mean, a very detailed analysis, but at least having some more information than what we had. So I think digitalization can be very positive in the sense that you can have the data, accurate data available also for the resolution authority. But as I said, it's also very important to make sure that you can easily have a good technological and operational fit with the acquired entity, because sometimes it's not you just analyze the entity taking into consideration if the business model is similar to yours. So in our case, it was, I mean, the business model did fit because they were probably stronger in SMEs, so it could help us develop our SME franchise. But we probably did not take into consideration the operational and technological fit, which was not as good as it was from a business model perspective consideration. So I think that also digitalization can help you achieve a quicker technological fit, because that can, of course, always hinder the possibility of having, a sort of post-acquisition. If you cannot, combine the systems in a fast way, that can be an issue, and it takes you years, I can tell you, to adapt the systems of the acquired entity to your systems. Even today, because we've come a long way in terms of digitization, moving our data to the cloud, but still, we find it very difficult, even without a bank, even within a bank like ours, when we want to develop a sort of a global platform and apply it in all the different subsidiaries, it's always an issue. So I would say we still need to work on making sure that this technological fit can be achieved within a shorter period of time.
Very good. Very good. And João, what was here the value of the franchise in stabilizing Novo Banco? And by the way, just if I may, why can we not sell a bridge bank in two weeks as in the US?
Well, if the first question, look, I think that post-resolution, there's always going to be problems around how the clients of the bank and the counterparties perceive the solution. It's easier when you have a buyer, for example, a credible buyer, a larger institution, which was the case in Santander. It's much easier. When you don't, which is the case of the bridge bank and also the open bank bail-in, it's much more difficult. And I do think that in those cases, it's all about the strength of the franchise. In the case of Besh, the bank had a fundamentally strong franchise in terms of their ability to do business and to preserve commercial relationships with the clients, in terms of the links with the depositors and the customers were fundamentally strong. The reasons why the bank failed were from a different nature, of course. And so this was really important because we had a bridge institution with a bridge bank for 3 years, which had many challenges during that time. We had the first sale process that failed. We had a difficult retransfer decision to make. We had stress tests done by the supervisory authority, which were not positive. And so, in spite of these challenges, the bank remained stable. There were, of course, some problems in terms of liquidity, but in any case, the bank was able to be preserved in terms of the confidence, and I think this was all about the franchise in the most fundamentally terms of the bank. On the other topic, I think, well, there's, again, we could have a panel on why it's difficult to sell a bank, more difficult to sell a bank in Europe than perhaps in the United States. And in our specific case, the context is very relevant, and regulation is also very relevant. Context because, in our case, again, the markets I think in Europe are still very much national. And in our case, Portugal was a small market, and the possible bidders for the bank were also not in a good shape at the time, and so there was not capacity, and the environment was not there. It's easier when you have a large market like in the United States, fully integrated, and of course there are many institutions able and capable of acquiring other banks. And of course, I also think that regulation does have a role as well. I think there's a lot of work to do in our case, in resolution in particular, and in the case of a sale of a bridge bank, in terms of making our lives easier. I think I didn't mean to say that the creation of a bridge bank was easy. I just said that taking the decision to create the bank was easy. I mean, it's just a resolution by the board, but of course there's a lot of work involved. But I do think that our regulation creates a lot of problems. For example, Penn said that in the United States that bridge bank doesn't have capital requirements. I don't entirely agree that it's the optimal solution. I think it's important to have a bridge bank that is adequately capitalized. But sometimes I also think that our regulation is too strict in that regard compared to the one in the United States, which I think is more flexible and also empowers the resolution authority more than the case in Europe.
Yeah. Thank you. Soren, I heard you agreeing with João on this. What would you advise for us to improve the setup of bridge banks?
Well, I was hoping I could speak about optionality more broadly a little bit, since that was one of the questions that you raised. I understand it's difficult to do that in -1 minute and 38 seconds, but I'll do my very best to keep it short. Now, I think what we are trying to achieve with combining different resolution tools, especially if we think about bail-in as the primary tool, right, is to sort of do during the resolution weekend what would otherwise need to be done during the restructuring phase. And that, of course, creates a lot more need for preparation on the side of the resolution authorities, much more need for operationalizing that, many more operational challenges that come with it. But it sort of relieves the pressure from that one instrument to sort of, to achieve a really feasible and credible solution in the long term and reestablish trust. Now, I think one of the questions that this raises is, do we need, if we follow that approach of a toolbox, do we need amendments to the legal framework, right? Are there legal frontiers in the way of doing that? And I think, fundamentally speaking, I think my answer to that question, and that's really a prima facie answer, is that we don't need to change the framework fundamentally, and the BRRD has this strategic optionality embedded. But of course, there is one aspect I think that warrants closer scrutiny, and that's flexibility in funding. Yeah? If we are increasing flexibility in the use of our tools, we probably also need to increase the flexibility in the way we can fund the combined application of these tools. And in that sense, I think the CMDI reform will set some first steps in that direction, and most likely there will be some amendments needed to the MREL framework, the way it is written in the law, but also in the way it is applied. So I think that would be my preliminary answer to that point. Thank you.
Thank you very much. So unfortunately, we ran out of time, and we are a bit already beyond schedule, for which I'm going to be heavily penalized by the legal team. But I think this also proves that it was a very enriching panel in terms of the intervention. So thank you very much to all of you. And apologies for not being able to open the floor for questions of the audience, but that's what the coffee break is also due for. So enjoy the coffee break, and thank you very much for your attention. Thank you. Thank you to all.
Welcome back, everyone. It's time now for our second panel on judicial protection and international investment arbitration in the context of bank resolution. And I will again ask our moderator, SRB General Counsel Karl Philipp Wojcik, to introduce our distinguished panel. Karl Philipp.
Thank you very much, Susan, for this short introduction. Ladies and gentlemen, it's my great pleasure to welcome you all here in Brussels or online to this third edition of the SRB Legal Conference. Thank you really for your interest, continuous interest in this conference, in this format, and for being with us. I think we've already had a very rich morning session, and I think the coffee break was well deserved. We were looking in the first panel on operational challenges when you have to do the resolution. But there is always a day after resolution. And that is when the lawyers in front of courts or other places come in. And I think that's a bit the purpose of today's panel. We want to look into the role of international investment arbitration in the field of banking regulation and banking resolution. And as Dominique said this morning, it is something which is probably not so familiar to many of us here, although this is a phenomenon which we now see more and more happening. Think about the Banco Popular resolution, was already mentioned, there was an arbitration case. But think also about the failure and then the rescue of Credit Suisse last year, and the announcement of many of the 81 bondholders who had been written down to initiate arbitration proceedings. So I'm extremely pleased and honored today that we are able to analyze and discuss these questions with a panel of distinguished speakers. And I'm thanking all of you for having accepted the SRB's invitation to come here and to discuss with us today. I would like to briefly introduce each of you, and I will start, and I will do this in the order of interventions which we have agreed among us. To my right, Petra Nemetskova. She's a member of the Commission Legal Service, and she's been working, as I can evidence myself, because I worked some time with her on a lot of different files, but now focusing in particular on international arbitration, international investment arbitration at the Commission. Thank you very much, Petra, for being with us today. The following speaker will be Professor Régis Bismuth. Régis is a professor at Sciences Po Law School in Paris, and he is an eminent specialist in public international law, among others also focusing on the international investment arbitration. And we will hear from him on the role of investment arbitration in the field of banking regulation in particular, and among other things. Thank you also very much for having come to Brussels, and I understand there were also other commitments actually in Paris, which you have basically made reconcilable with our panel here. Our third speaker is then Mrs. Sonsoles Centeno. She's now a partner and director of a Brussels law office of a leading Spanish law firm. And before that, she had a distinguished career in the Spanish administration as a state attorney. And in that capacity in particular, she has been involved in many EU law cases, and she also contributed significantly to EU law in the field of international investment arbitration. So also thank you very much for being with us and sharing your experiences. Our fourth speaker then is Mrs. Cecilia Carrara. Cecilia is a partner in a leading Italian law firm, and she is actually an eminent practitioner in commercial and international arbitration. And she has acted as an arbitrator. So she brings this perspective from inside, and we are very much grateful to you that you will share also your insights on this. I would like to give the floor now to our first speaker, to Petra. We are already a little bit behind time, so I would really be grateful to stick to the time. Otherwise, I will get a message from my team, and which I then have to relay in one way or the other, so that we also then have afterwards a nice discussion here with questions from the audience. And with this, again, thank you very much. Petra, the floor is yours.
Thank you. Thank you very much. Welcome. Thank you, the organizers. Thank you, Carlo Philip, for inviting me to speak on this topic. Just a caveat, as you said, we are lawyers, we know each other, but here I speak strictly in my personal capacity, also because I'm personally involved in some of these cases, and of course for academic purposes, so the views are strictly personal. But the idea here, for me at least, is to set the scene a bit, to tell you about what are the main challenges for the Union, for Union law, in the field of investor-state arbitration. So I will not speak so much about the banking union, the challenges of that field in the financial field. I think that's for later. But I would like to set the scene of what are the main issues and challenges, and sort of also what is currently happening in this field. So first of all, on the so what are we dealing with? We are dealing with commitments that the Union sometimes, but more often member states, made in bilateral investment treaties with third countries, or sometimes also in a multilateral treaty, sort of with sometimes among itself, but also mainly with third countries. This is typically, for instance, there are many cases in the energy field. You probably heard about the Energy Charter Treaty. So this is one of these typical treaties where issues of investor-state arbitration arise, and which are a very hot topic in the Union these days. And these treaties, as you know, contain a dispute settlement mechanism whereby the parties to that agreement submit to the jurisdiction or to that tribunal the questions on interpretation and application of that particular treaty, and investors of the contracting parties then can go to that tribunal and sue a member state, a contracting party to that agreement that is sort of for breaches of obligations or rights that they understand are stemming from that agreement. So this is mainly a tool for the countries, for the member states, but also for the Union to act in the international field, in the field of sort of international relations in relation to third countries and to investors in third countries. And that's the first point. We are having cases in the Union which deal with the with the so-called intra-EU situation. So where you have a investor from a member state suing another member state or suing the Union under sort of before the jurisdiction on one of these tribunals. So typically it's arbitral tribunals under the ICSID Convention, the SCC, and the UNCITRAL. Now, why we have these cases? Well, typically because the BIT treaties, so the bilateral investment treaties, were concluded between member states of the Union and third countries that subsequently became member states. So this is it's I would say an accession problem, which is now slowly being fading away, and I will also say why later. But this is typically cases arise. So the famous Achmea case arose from a bilateral investment treaty between Slovakia and the Netherlands, for instance, and the case at stake happened when Slovakia was already part of the Union. And in the same way as you have an internal situation, so where these, I think everybody agrees that this treaty would not entitle a national suing its member state before a national court. If we transpose this to the European Union, you have the same problem. I mean, can a EU investor, so investor from one member state, sue another member state in the Union context? And this is where there is, I would say, a big disagreement between the arbitral tribunals on the one hand and the European Court of Justice, and also now the national courts of the member states on the other hand. And these cases, sort of this problem, made its way before the European Court of Justice, who ruled very categorically in a number of cases. The first one was the Achmea case, that these type of investor-state arbitration clauses in international agreement concluded between the member states of the European Union are contrary to the EU treaties to the extent they circumvent the, let's say, the jurisdictional, the judicial setup of the EU treaties. That, well, this is going to specifics. So in Article 19, you have sort of the Article 19 of the Treaty of the European Union set up the fact that it's only the European Court of Justice of the Union that interprets and can apply Union law. And also Article 344 that forbids member states from recoursing to alternative means of dispute settlement member states. And also, of course, Article 267, which is the famous preliminary reference, because arbitral tribunals are not considered as courts within the Union law and therefore cannot ask preliminary references. Therefore, there is not this means for a ECJ to be called upon interpreting questions of Union law. So this was the Achmea case, which was specifically about a bilateral investment treaty, so the famous Slovakia and Netherlands. This then also transposed in a later case, in the Comstroy case, to a situation of an investment clause, of a dispute settlement clause in a multilateral treaty, such as the Energy Charter Treaty, where the court ruled that even if we are talking about a multilateral treaty, when you have a dispute settlement clause, that clause governs bilateral relations between two of the contracting parties, and therefore the Achmea jurisprudence is equally applicable in the framework of multilateral treaties. Between Comstroy and Achmea, there was a big discussion whether indeed Achmea would apply to Energy Charter Treaty. Why? Because precisely you have many intra-EU cases in the framework of the Energy Charter Treaty. And to just top it all off, the court then confirmed the jurisprudence in a number of other cases. But what is important also for the enforcement phase is, I would say, called the Romaca order, which is an order in the Mikula saga that Sonsoles knows very well. But where what is important here is that there the court confirmed black on white that any intra-EU arbitration award, including an exit award, is unenforceable shall be set aside by national courts of the European Union. So this is a pretty strong statement, especially when we consider that the Exit Convention gives the right to for the national courts to basically enforce that award quasi automatically, I would say. So this is really a statement of primacy of EU law in a situation. I would like to sort of emphasize that in a situation that is intra-EU situation. And again, think of what would happen within a state. So this is the same, but at the union level, yeah, in the intermarket. This is always a bit the logic behind. Now, big question also: what happened in extra-EU cases? So are there any limits that the union law poses for extra-EU cases? And there, if you're looking for some case authority, for some case law, I think the SETA opinion of the full court of the European Court of Justice is very illustrative, because it really explains the reasoning and even sort of goes into, I would say, practical guidance of what an arbitral tribunal under a bilateral investment treaty, such as the Canada-EU, or any other treaty, such as the Mexico-Spain, for instance, which was at stake in the Banco Popular arbitration, should be beware of. So. It reinstates, in that opinion, the court reinstates that indeed the intra-EU dispute should be out of jurisdiction of the tribunal, because, as I said, the tribunal is really meant to address sort of a situation between an investor from a foreign, from a third country and the union, or union investors investing in the third country, here Canada. But it also looked at what the arbitration tribunals should do, or sort of ideally would need to bear in mind when examining a question that may touch upon EU law. And indeed, I think there are certain statements in that opinion that are very useful. First, the ECJ, the European Court of Justice, agreed that those tribunals do have jurisdictions in extra-EU cases. That it is well possible for the Union or for member states to submit to the wisdom of an external tribunal outside the EU structure, as regards the interpretation and application of the provisions of a investor of an investment treaty to which they subscribe. But it posed some limits, and those limits for the Court of Justice are twofold. First, the arbitral tribunals cannot have the power to interpret or apply provisions of EU law other than those of the international agreements at stake. So in the case of the CETA agreement, you can only interpret that agreement and not any other EU law. And also, and that's important, they cannot make awards that could affect the autonomy of the EU legal order. You may ask what that means. Well, the court went a little bit further in that interpretation and basically gave examples that it would, for instance, happen if the arbitral tribunal would call into question, for instance, the level of protection of a public interest that led to the introduction of certain restrictions under Union law or of certain rules. So this type of questions would probably be trespassing the competence that the European Court of Justice considers that these tribunals should have under bilateral investment treaties when looking at questions of EU law on the merits. So this is the story of the ECJ. Now, what do the arbitral tribunals say? So, indeed, they may not be very happy with that, I would say, fairly restrictive approach from the European Court of Justice, which may be very logical for us, but indeed, may be harder to swallow for an arbitrator who is legitimately called upon deciding on a dispute that is within the scope of a specific agreement. I quite like the note, the quote from the Euros Arbitral Award, which says that the decision of earlier tribunals on how to approach the question of EU law have been markedly inconsistent. And if you want to have a nice overview, maybe you can go to that award because it really gives quite a nice bullet point summary of what has been said so far. I would say that there's a certain trend that, for example, that as regards the bilateral investment treaty, the tribunals tendency. So really, you have all, but as regards the bilateral investment treaty, the tribunals have been more respectful of EU law than in the context of the litigation concerning the Energy Charter Treaty. At least this is a bit the trend I could have, I have identified. In the earlier judgment, for instance, in Electrabel or in Eureko, which is the award that then gave rise to the Achmea ruling, you have indications that EU law can be classified as international law. You have you have also notions of the arbitral tribunals decided that it can consider and apply EU law both as a matter of international law or as a matter of German law, which would be the matter of fact. Then you have tribunals that do disregard the question of EU law and of the fact that you have a court somewhere in Luxembourg, which is the one who is called to interpret and apply union law, saying that intra-EU arbitration should not be, are contrary to EU law. So these are the Nova Energia, Masdar, Sheren, Antin cases where they say black on white again that EU law is not applicable. and is irrelevant to the determination on jurisdiction of the tribunal. And then you have one exception, which is the green power award, which is the only time when the arbitral tribunal did decline jurisdiction in this situation. So really, as you can see, there is a situation of disparate interpretation to put this diplomatically. As regards enforcement, and I will be quick, within union borders, the national courts are of course called to fully respect the ECJ case law, and therefore they consistently decline to enforce intra-EU awards. So the investors typically go to third countries, those who are, for instance, part of the exit convention, and there the question arises of, of course this is a difficult situation that those courts are dealing with, because they have to decide many times on questions entailing fairly complex EU law questions, such as involving really matters that are, I would say, specific even to the EU legal order, such as questions of state aid, question of indeed autonomy of the EU legal order, how the union works really, and therefore, at least the position that the union is defending there is to put very strong emphasis on the principles of comity, on the principles of deference, and on really trying to make those courts understand that certain questions of EU law should be rather dealt within the union than outside. But again, there is indeed a big question mark on how to square that together with, for instance, the obligations that those third countries have under the exit convention. As I said,
we need to be mindful of time. So if you we can come to that also later. But I leave to you to finish.
Yeah, just one last slide and one last remark. Because of of course, the judicial, the court cases always come after the problem. So what the union is trying to do, especially in relation to the jurisdictional issue, to the intra-EU arbitrations, is to have a proactive response. And that's why in 2019 the member states got together and decided to terminate in one treaty the bilateral investment treaties that were still existent in the union legal order after accession. So all those treaties have now been terminated, but they still have some sunset clauses, some of them that still pose problems. And the same is now happening in the sort of other field that raises all these questions in the framework of the Energy Charter Treaty, where I think since October 2 years ago, there have been negotiations ongoing on having an interpretation agreement, again, between the member states and the union, confirming that the dispute settlement clause in that agreement should not apply inside the union. So this is a bit the proactive response that the union is trying to make, and that would also hopefully make arbitral tribunals and courts of third countries take that sort of question into consideration, not just through the application of EU law, but also through the need to apply an international agreement under public international law that has been now made valid once this happens. So I will pause there. As I said, I tried to give the overview, and now the floor is yours.
Thank you very much, Petra, because I think you introduced us basically to the background, and you showed that international investment arbitration in the field of banking and banking resolution actually needs to be seen against the bigger picture. And there are other policy fields in the European Union where this topic has come up and where the findings, of course, are also relevant. And I'm very grateful also that you introduced this idea of intra-EU bilateral investment treaties, extra-EU investment treaties. And there is something I think we can all take away. Judges in the European Court of Justice are very jealous, apparently, of their role. So there seems to be also something more behind that. And I think this is probably a good, a very nice statement which you had made, Petra. Thank you for that. And with this, I think we can now turn to Régis, and Régis will look at the topics more also with a view on banking regulation in particular. So I pass this to you. Régis, please, we are looking forward.
Thank you very much, Galvelik. Thank you very much to you and to the SRB legal team for this invitation. So in the next 12, 13 minutes that are going to start right now, I try to outline what are the main trends of investment arbitrage tribunals when assessing the acts of banking supervisors. So there have been many cases, many financial-related cases in investment arbitration in the last 20 years. I looked yesterday on the investment arbitration navigator on the UNCTAD website. It lists actually 133 financial-related cases. Some of them are relating to monetary exchange control, some of them are relating to sovereign debt restructurings, but I would say that there are approximately 70 cases relating to financial regulation and banking supervision. So not all are related to the issue specifically of banking resolution, but I've decided to review a few cases that are directly related to banking resolution or indirectly related to banking resolution. So for instance, some cases concerning the revocation of banking license, which may seem to some extent relating to banking resolution, but the case arose when the concept of banking resolution didn't even exist in EU law. So it could be about the revocation of a banking license, it could be the decision in relation to the composition of the bank's capital, the refusal of the bank supervisor to rescue a bank, and of course, liquidation or bank resolution stricto sensu. I'll be very short on this slide because many things have already been said. The fact that the jurisdiction of investment tribunals in this case is usually based, when we are talking about banking resolution case, banking regulation cases, on an international investment agreement, so intra-EU possibly, but most of the cases we're going to discuss today are based on a non-intra-EU investment agreement. For instance, the investment agreement between Mexico and Spain in the Banco Popular case. When it comes to the attribution of the banking supervisor as to the state, arguments have been made in the earlier cases about yes, but the decision was made by the central bank, which is independent from the state, or was made by the banking regulator, which is independent from the state. Of course, there's no issue of attribution. This is an act of a state from a public international law standpoint. And also the third point, we need to keep in mind that when assessing the acts of banking supervisors in the context of investment arbitration, their legality is assessed in light of the investment treaty, not in light of the domestic legal framework that is applicable, even though the domestic legal framework will have a role to play in that context. And before discussing the standards that have been applied by investment tribunals, it's important to keep in mind what has been done at the domestic level when we're talking about the responsibility of banking regulators, the responsibility of states when rescuing a bank. Actually, when you look at the general principles of administrative responsibility of financial regulators, financial supervisors in France, in the UK, in the US, in Italy, in Germany, etc., they all rely on different concepts. So for instance, in France, we have this requirement of what we call faute lourde from the supervisor, this concept of recklessness, for instance, in the BCCI case in the UK in the end of the 90s. The necessity in Italy to consider whether the acts of the supervisors were done within the limits of its discretionary activity, the discretionary function exception under the Federal Tort Claim Act in the US, and so on and so forth. But if you look at these decisions, what's interesting, in fact, is that they revolve around different, or they're based on different, let's say, legal concepts, but they all revolve around, you know, the same concerns. The fact that courts are not here to second guess the administrative decision that have been made by banking regulators, that there have been moral hazard concerns, that we have to take into account that banking regulators act in a very complex environment, that there are considerations of financial stability, and so on and so forth. And the same concerns actually exist in the context of EU or other cases of EU law, or in other cases before the European Court of Human Rights, or in the EFTA context. I've mentioned here the iSafe case before the EFTA court. I've mentioned here the Dennis Greger case, which is relating to the Northern Rock collapse in the UK. So basically, we have the same concerns regarding the fact that the financial supervisor of the state is not or cannot be the guarantor of risky decisions that have been made by the bank, by financial institutions. And when you look at the international standards that we have, the core principles of banking supervision of the Basel Committee on Banking Supervision, or what we usually call the prudential carve-out in international trade agreements, both actually recognize, all these instruments recognize that we must protect the decisions that have been made by financial regulators to protect financial stability for prudential reasons, and so on and so forth. So I'll try to outline now a few points regarding the attitude of investment tribunals in bank resolution and bank regulation cases. First of all, I'd say really a few words about the standard of review. This is exactly the same thing that I've said concerning the decisions that have been made at the domestic level. Investment tribunals are not here to assess the correctness of the decisions that have been made by banking regulators. We only evaluate their acts or omission in light of the treaty standards, fair and equitable treatment, and so on and so forth. And we recognize a margin of discretion to investment tribunals in this context. What is important, and it echoes an expression that had been used by Serena this morning, the fact that in the context of the EU banking resolution, we have a strategic optionality. What is important, what is really important, is the fact that even though arbitral tribunals do not assess the acts and omissions of banking regulators in light of the domestic regulatory framework, the domestic regulatory framework actually provides a matrix to assess the behavior of banking regulators. So there's a margin of discretion, but it is important to see actually whether or not the regulatory framework empowers, compels or not, authorizes or requires the banking regulator to act in a certain way. So for instance, in the Banco Popular case, the arbitral tribunal actually had a look at the regulatory framework and said, well, it is true that banking authorities have this possibility to issue an emergency liquidity assistance, but if you look at the regulatory framework, it's just an option. It's not an obligation. So it does not create a subjective right for the investors. The investors could be the shareholders, the depositors, the bank itself, and so on and so forth. It does not create a subjective right to an ELA. Likewise, there's no subjective right, even though this is something that could be done by the banking authority. There's no subjective right to request, for instance, public financial institution oh no, I'm sorry. there's no. When it comes to short selling, I mixed up. I'm sorry. There's no right. There's no subjective right, for instance, to have the banking institution to adopt a short selling ban. Likewise, even though nothing is planned in the domestic regulatory framework, there's no subjective right for the investor for the banking institution to act in a certain way. So, for instance, to prevent Spanish agencies, municipalities, and state-owned entities from withdrawing funds from Banco Popular in that case. What is important, and I think that the Bank Meli versus Bahrain case is interesting in that situation, is that it more specifically look at what are the procedural obligations of the banking authorities in light of a regulatory framework. So, for instance, the rule book of the Bahrain authority in the Bank Meli versus Bahrain actually provided that the administration of a licensee is a very powerful sanction, and it will be generally only pursued, and the authority will only generally pursue this option if less severe measures are unlikely to achieve its supervisory objective. And what is important in that regard is that it creates, to some extent, procedural obligations to show that this option has been contemplated and why this option has not been adopted by the banking authorities. And there is a link here with the procedural obligation, we could say, of a necessity for the banking supervisor to maintain a record of the reasons for the measures that have been taken. Well, I do not have a lot of time, so I'd like to perhaps to finish with this question of a red line of discrimination. I've tried to show that there are specific procedural obligations for the banking supervisor. This is what appears in black, for instance, in this slide. So obligation, so more or less follow the rule book, explore the options when the rule book actually says that options need to be explored, and so on and so forth. So these are the obligations. And in between, there is a margin of discretion. But even within this margin of discretion, the acts or omissions of the banking supervisor could be scrutinized. And mostly when it comes to discrimination. Of course, if it's a nationality-based discrimination, this is definitely a red line. But if it's a discrimination based on, let's say, the nature of investors, the nature of depositors, the origin of depositors, and so on and so forth, this is something that needs to be justified. Why has there been a discriminatory treatment between different types of depositors, between different types of shareholders? A very last slide, just 30 seconds, the fact that arbitral tribunals also take into account the fact that banking resolution is a very sensitive issue and that banking regulators need to be extremely careful in their communication policies when they make certain decisions and when they make also certain statements. Thank you very much. 14 minutes.
Excellent. No, very much. I think it will be also appreciated by the audience, and so that we can ask questions. But thank you very much, Regis, for bringing this perspective in. And indeed, I like very much the reminder what is actually the legal benchmark in arbitration cases, which is a different one than in court proceedings, which are based on national or European administration law. And however, that there are similarities when it comes to the margin of appreciation, for instance, but also when it comes to discrimination.
If I may add just one thing, is I remember that Keynes said in its a proposal for an international currency union, this very famous, very famous words. The more difficult question is how much to decide by rule and how much to live by discretion. He was talking about financial assistance of state. And this is exactly the issue here. How much to decide by rules, what do you put in your rule book? Yeah. Once it is put in the rule book, of course, you will have to be very careful about whether it's written in open-ended terms, whether we are in the context of strategic optionality, etc. But this is really the most important question here.
Yeah, indeed, I think we can all agree on that. And I think also the last slide on the communication policies links nicely to what Andrew Metrick said this morning, that one of the lessons is communication. So basically, it's not only for policy purposes, but it's also for legal purposes that very carefully drafted communication is key. We're already almost starting a discussion, so I would not. I would now like to give the floor to you, Sonsoles, and to listen to your perspectives on the topic.
Thank you very much. Thank you, Carl Philipp. Thank you to the SRB for the invitation. I feel the pressure of the time constraints. It's worse than a hearing in Luxembourg, but I'll try. After your 13 minutes straight, I will try to do my 7 minutes
you can
intervention.
Time after the talk.
So, I will be talking, of course, from my EU law perspective, and I have to say that after 10 years of dealing from the EU law perspective and trying to understand arbitration, there are completely different mindsets. So how are we going to solve this problem? We have a problem. So when preparing for this panel, I revisited the conference of George Berman in 2019, distinguished professor of Columbia, and his lecture started as follows. It is no exaggeration to describe the relationship between the European Union and international arbitration as the most dramatic confrontation between two international legal regimes seen in a great many years. Dramatic. I'm not so sure whether it's dramatic, but undeniable frictions exist. So what I see, and I've been a lawyer for 20 years, litigation is more and more complex nowadays. And as the EU deepens its integration, the relationship between national, EU, and international legal orders is difficult. So many questions arise, and one of these questions could be, can non-EU investors rely on a BIT taking into account the origin of the damage? And is a decision taken by an EU institution? Of course, these questions come from the Del Valle case. So the banking sector is not immune, and I think you have now, that there can be a problem, and it's the moment, as you deal as a resolution institution, you deal with crisis, we need to reflect in systemic challenges. So I will try to do that in these 5 minutes, and I will, the starting point will be the Del Valle case, and I will deal with 2 questions. One, it's about judicial protection in the EU, because the title of the panel was Judicial Protection and Investment Arbitration. I would say judicial protection against investment arbitration, but maybe that was not politically correct. So let's try to put two worlds together, and I'll try to be maybe a little bit critical also to the EU. We are here just to reflect on things, and I'll try to do so. So the Del Valle case. The Del Valle case, for me, I think it was a test case. It was the first resolution decision, and we all knew that we needed to have it right. And we knew that we were going to have court cases. We knew that it was going to be challenged in all possible places, Spain, and of course the General Court. But I don't know from the SRB, but we didn't think we were going to have an arbitration case. So we had first the court cases came, the General Court, many cases, and I was not, at that moment of time, I was not the agent for the Spanish government. I was just coordinating the team, and the state attorneys did a magnificent job together with you and, of course, the Commission. And The problem here, we had the court cases came in 2017. The arbitration case came in 2018. Then, in the case of the General Court, it was against the decision, and it was the SRB and the Commission that they were defending, and Spain was intervening together with in support of the SRB. But what happened in the arbitration procedure? It was against Spain. And there, the claim, it was against the acts of the Spanish institutions. But, of course, the framework was all the resolution situation. So we all know that the result was a happy ending for the institutions, for Spain, and for the process. But many questions we have many questions that we need to solve for the future. One of the questions is the allocation of responsibilities. What would have happened if the final award had ordered Spain to pay compensation? That was the question, and that was a question that we ask ourselves in the process. And this is a process, I think it has not an easy answer. For me, it's a paradox that a member state is sued and will have to pay for merely implementing the EU law framework. And the second question comes with what Petra said when referring to the CETA opinion. Whether certain EU decisions and its implementation by member states should be or should not be scrutinized by investment arbitration tribunals. So let me continue, because if not, I will just finish my time. So judicial protection in the EU. Why investors go to arbitration? In general, they go because they want to, they think they might have more chances to get compensation. So my first reaction would be, this would be difficult to change if they think or they perceive they can have more chances to have chances in the arbitration fora. This would be difficult to the EU to prevent. But we should reflect on another debate that normally doesn't go together with arbitration. It's enhancing the level of protection in the EU. There was a communication of the Commission, if I recall well, it was 2019, and it was something like the EU has enough judicial remedies. And as a statement, it's okay, but then I would ask myself whether, if I'm a Spanish investor and I have a problem in another member state, I won't say which member states, I have enough safeguards to think that my case is going to be resolved according to the EU standards. And this has to do with the quality of justice, allocation of resources in national courts, independence, and rule of law. But this has another question too, not only for national, because sometimes we think we are only the member states are the only one that have problems. The EU should also think about the standards on review, for instance. Is it the Court of Justice a little bit too restrictive when we refer to access to justice and the concept of direct interest? Or is the standard of review, when it comes to the proportionality principle, the right one? And then I leave it open, probably for the debate. I don't have the answer. But my next reflection then goes a little bit to what Regis had to say. What about the safeguards of the system, of the resolution system? If we have awards coming from investment tribunals that could damage the whole system, what can we do? Is it something we can do? Is it something we can prevent? The two channels exist, but maybe in the international treaties that the EU has to sign, or the revision of the extra EU BITs that member states need to do, they should take into account the need to include safeguards of the You have referred to the prudential and the need of preserving the whole system. The CETA opinion spoke about autonomy. This has been criticized by many authors, saying, what do we mean for autonomy in terms of investment arbitration? But there is something that we need to preserve, not only internally, but also from the external perspective. So the 2018 financial crisis showed the dangers of interconnectedness of the banking and financial system. So I would say that the lessons that we should have learned from that and from the Del Valle case is that we need to include safeguards in those treaties. We need coherence between what the EU in its international agreements, either with exclusive competence or shared competence, and on the other hand, the extra EU BITs of member states should be coherent. But also, we shouldn't forget that investment arbitration is about attracting investments to the EU. So this means that we cannot kill the system, and we need a balance between attracting investment. We hear all the time the green transition, the digital transition. We need investment. The EU needs investment, but at the same time, we have an interconnected system that we need to preserve. So I stop it here, and I'm happy to engage in the debate later.
Thank you very much, Sansoles, also for opening up on this last perspective, but also bringing in, I think, this idea of trust in the legal protection afforded by courts in the European Union. Maybe something we can further discuss a little bit later. I would now turn to you, Cecilia, and indeed, we are very much looking forward also to hear, as I already said, the perspective of a practitioner, an arbitrator from inside. Therefore, please, looking forward to
Thank you very much. I will stand, if you don't mind.
Absolutely, sure.
Again, like the other panelists, I wish to thank the SRB for the invite. I'm delighted to be here and also to offer my perspective as private practitioner. So I act both as counsel and as arbitrator. So there again, I have the double kind of experience. I would like to say at the beginning that for professional reasons, I will not comment on the Achmea and Comstroy decisions. I will just focus on the cases that involve extra EU investors. And my intervention in particular will be on concurrent proceedings. What happens, especially we've heard in the banking sector, there are multiple claims. What happens when it comes to concurrent proceedings? Is it possible? And what are the remedies and what are the interactions? So, as has been said before, foreign investors are generally able to commence a claim both against national courts, but they too have different toolkits, and they can choose lawfully between the remedies that they can exercise. So they can also choose to pursue an investor-state arbitration, mostly, as was pointed out by Sansoles, for the time being, the attribution would point to the state where the decision of resolution has been taken, even if multiple authorities have participated in the decision-making process. This usually happens on the basis of the BITs that have been concluded between a state and another state. So the state is the host state, and the other state is the state of origin of the investor. And this is why, under the BITs, there cannot be an issue of responsibility of European unions, because the BITs would be between one member state and another state. So even if now intra-European arbitrations, investment arbitrations, are limited and I would say almost impossible. European law does not interfere on the position of extra EU investors, and in particular arbitral tribunals seated outside of the European Union, and we don't have to think far. We can look at Switzerland or we could look at London. These arbitral tribunals do not consider themselves and are not bound by European law, and they are free to take on cases. Enforcement of awards, as we have heard from Petra, in the European Union is mostly impossible, but it still remains possible to seek enforcement outside of the European Union. So we have a large world, and again, it's a choice of the investors where they look at the places of enforcement. I'm going to talk today about very, very recent examples. So hopefully there is still no literature. So I beg your pardon if this will not be a very academic intervention, but it's new cases, so maybe there is food for thought. So one recent decision that I would like to comment, again, looking very close to the borders, is in Switzerland. There was a decision rendered by the Tribunal Fédéral in April 2024 that has accepted jurisdiction on an investment arbitration case. And I would like just to read out to you a very short passage of the decision. Le tribunal arbitral juge utile de rappeler que le présent litige s'inscrit dans le contexte plus large de la licéité même du recours à l'arbitrage d'investissement pour régler des différends présentant un caractère intra-européen. Depuis plusieurs années, les organes de l'Union européenne mènent en effet une croisade contre les arbitrages internationaux. La Cour de justice a également souligné que la fixation du siège de l'arbitrage sur le territoire d'un État membre entraînait l'application du droit de l'Union européenne, dont les juridictions nationales ont l'obligation d'assurer le respect. Une telle obligation ne s'impose pas aux tribunaux des États ne faisant pas partie de l'Union européenne, tels que la Suisse. So here we hear a little bit the tension that was mentioned before, but again, there are challenges that come with the tensed approach that the European Commission itself has, in a way, contributed to create. So we can draw a preliminary conclusion that it is possible even today to have parallel proceedings in front of investment arbitral tribunals and in front of national courts of the member states. It is possible to imagine that the same banking crisis originates disputes in front of the national courts, in front of the ECJ, if it is for decisions coming from the Single Resolution Board, as well as investment arbitrations, at least in cases involving extra-European investors. So I will mention to you 3 examples, and maybe we can draw some conclusions together in the debate, and of course I am open for questions. These examples will also show a little bit that arbitration is not necessarily the fast-track scenario that one would think of. So I thank Monica in the previous panel for informing us that out of the 25,000 claims against the bank, there are still 8,000 pending. I think plus the investment arbitrations that were 2 and then became 1. But I think they would still be pending in arbitration. So most probably, even if we try to be efficient and quick. So our first example that I would like to bring to your attention is a saga that finished in 2023 in December, after 20 years of proceedings. This was the case ABC versus Tunisia. ABC, an investment company, invested in the Bank of Tunisia, Banque Franco-Tunisienne. And it contested that Tunisia exercised its power to prevent ABC from taking control of the bank. ABC in Tunisia initially commenced a commercial arbitration under the ICC clause that they had in their agreement. An award was rendered in favor of ABC, but surprise, surprise, it was not enforceable in Tunisia. That, of course, was the host state. There were also a series of civil and criminal proceedings in front of the Tunisian courts, and Tunisia ultimately requested the administration of the bank. At that point, ABC commenced an investor-state arbitration under the Netherlands-Tunisia bid, because ABC had headquarters in Netherlands. It started in the 2003, seeking restitution for the de facto expropriation of its controlling state in Banque Franco-Tunisienne. And then there was a very complex story. In 2017, there was a first award by majority on jurisdiction. Then there was another award that was formed by a different tribunal. So there was a change in the arbitral tribunal. And it issued an award in December 2023, accepting the responsibility in principle of Tunisia, but out of the claim that ABC had claimed of 12 billion, it awarded to ABC compensations equal to the 0.003% of the amount that it had sought. So and the tribunal also refused to order Tunisia to pay ABC's legal fees. So ABC's ended up basically with a minus at the end of the story. So one would definitely say a Pyrrhic victory. The second example that I would like to briefly discuss is Adamakopoulos against Cyprus. This was one of the many cases that started after the Greek crisis. Now, why am I discussing this case? This again was a case that only finished in May 2024. So now I'm not aware that the award is yet public. So I base what I say on the press release that was disclosed. And here the tribunal initially found in favor of its jurisdiction. So it was the second out of many cases where mass arbitration was made possible in investment arbitration. And in that case, the tribunal thought that the intra-EU character of the case would not stop it. Again, it was many years ago, and the European law has evolved since then. What happened now? That the tribunal dismissed entirely all claims on the merits, May 2024. So this, again, is an important case also because it reinforced a precedent case, which was Abaclat against Argentina, where I was co-counsel for the Italian bondholders against Argentina, which was the first precedent case of a mass arbitration. There was a lot of discussion at the time whether investment arbitration was a possible tool for multiple claimants, and the answer was yes. So again, that opened a significant trend. And I think now there is no discussion that it is possible. There may be discussions whether it is the best option. But just something that may be of interest also today, in the Abaclat versus Argentina case, there were initially 180,000 bondholders. At the end of the proceedings, 60,000 bondholders, and the case settled. So if we have to look at the settlement result, it was a win-win for both parties. By definition, settlements are win-win, maybe more favorable for one party than the other. I can only say that the bondholders were very happy, and in particular, the Association of Italian Banks were extremely happy, because in that case, the arbitration was financed by the Italian banks themselves. Why that? Because the Italian banks had placed the Tango bonds and were afraid of being claimed in front of the national courts for misrepresentation, which is in fact what happened in many cases. So for those investors who chose the way of the investment arbitration, Task Force Argentina, that was set up by the Italian Banks Association, ask the investors to waive their rights to pursue their claims in front of the national courts. So this is another commercial way, I would say, to limit concurrent proceedings and streamlining the proceedings in one direction rather than the other. My third example, I will dwell on it very briefly, is the Belakan versus Kyrgyzstan Republic case. Why am I mentioning this? Because again, it's another set of typical circumstances that can occur when it comes to a bank resolution. Here, the Kyrgyz Republic Central Bank placed several banks under administration. It was clearly a systemic acute situation, and the Kyrgyz authorities placed also Manas Bank under sequestration. The local courts rejected all claims brought by the bank in question, and there were criminal investigations that initiated, including against the main shareholder and the officers of the bank. The sole shareholder of the bank was a Latvian national, Belakan, and he commenced an UNCITRAL investment arbitration seated in Paris against Kyrgyzstan. An award was rendered in favor of Belakan, but then the Paris Court of Appeal set aside the award. And the court went up to the Court of Cassation that in 2022 upheld the decision of the Court of the Appeal. The Court of Appeal had decided not to allow the award to be effective in France because it found that the Belakan had used corrupt means for the purpose of his investment and that there was a degree of money laundering involved. So here we see that even if there is investment arbitration, there is still a scrutiny that is left with the courts when it comes to the protection of the ordre public. Of course, the notion of ordre public changes over time, but one does not have to think that arbitration is completely immune from any kind of sovereign control. So final remark, what will happen now with after the takeover by UBS of Credit Suisse? There are many rumors on the market that several investors from Asia are looking at setting up a group structure to commence an investment arbitration against Switzerland. So far, FINMA's actions have been considered by public authorities appropriate. But of course, investors may want to have a second bite at an apple with an investment arbitration route. There have been litigation in front of the St. Gallen courts, again reportedly by the press. The main object probably of these proceedings was to obtain access to documents that were otherwise secret. It is not easy to detect who all the bondholders, the 81 bondholders, are potentially involved, but the St. Gallen court has not only denied the request, but also denied the possibility of a mass action, finding that the kind of remedy that was exercised was an individual kind of remedy. So here it is worthwhile monitoring the evolutions, and maybe the next edition we will be here to discuss more about the case. So thank you, and I'm open for questions, of course.
Thank you very much, Cecilia, also for opening this universe and case law, and also opening the last outlook. I think that listening to you and the 20 years of arbitration in the Tunisian case, the next edition of the SRB Legal Conference is hopefully taking place earlier. So I'm not sure how long we have to wait if in the Credit Suisse cases. So we'll see. But I'll take up your offer. So thank you very much. We have still a little bit of time, which is good, and I actually would like to tell you a little bit how we would like to go on. I will I will go actually to the audience in a minute to give you the floor. But before doing so, I would like to hand the floor over to Mr. Caparroso from the Spanish Resolution Authority, FROB. And why? As you know, an essential feature of the single resolution mechanism is basically the cooperation between the SRB and the national resolution authorities. And it is for this reason also that we would like to give the FROB, our colleagues from Spain, a privileged and special treatment in this case. And I think given that FROB was very closely involved in the Del Valle arbitration, we will appreciate listening to Ignacio for some practical insights, and then we will indeed give you the floor for questions. Ignacio, please, thank you for having you.
Thank you very much, Carl Philippe and the SRB for the invitation to share FROB's experience in the Valle arbitration. As a first point, as it has already been explained in the panel, this case consisted of an investment state arbitration proceeding initiated by former investors of Banco Popular of Mexican nationality against Spain, based in the bilateral investment treaty between Spain and Mexico. The claimants sought a total relief of 647 million euros, and the proceedings were held under ancestral arbitration rules. In the award, the tribunal found that Spain has acted legitimately and reasonably under the limits of the treaty, and so it dismissed all the claimants regarding the merits. As a result, the tribunal considered that the claimants should pay a total relief to Spain of 7 million euros as legal fees and other expenses incurred during the case. As you can imagine, this so complex and challenging case gave us a lot of lessons to learn, but I would like only to highlight 3 of them. The first one is from a practical point of view, in the case of Banco Popular, as in the other arbitration proceedings in the banking sector, these cases are very, very lengthy. And from the day of the announcement of the claimants that they will go to initiate arbitral proceedings to the date of the publication of the award, took more than 5 years. Also, another aspect I would like to highlight is that these proceedings are very heavily resource-consuming proceedings for the authorities involved, which require also highly specialized legal advice. In the case of Banco Popular, the Spain's State Legal Service coordinated the Spain's defense with the support of Banco de España, the Spanish Securities Market Commission, and FROB's legal departments. But as it is common in the international legal proceedings, the intense work of production of documents, the several written submissions and exchange between the parties and the tribunal, and also 2 hearings, which included 10 witnesses and 25 experts, requires the hiring of the arbitration teams of 2 international law firms. All in all, I believe that the strong involvement and the smooth coordination between the different Spanish authorities involved in the case was key for the successful outcome of the case. Secondly, as already mentioned in the panel, I would highlight that another aspect that the Spain, including in this defense, in this case, most of the claimants in the arbitration had breached the two clauses of the Spanish bilateral treaty with Mexico, the waiver and the fork in the road clauses, which basically limits the concurrent proceedings by prohibiting investors to sue the states in different fora if the fundamental basis of the claims is identical. In the case of Del Valle, most of the claimants has already initiated parallel proceedings before the European Court of Justice, seeking the annulment of the decisions taken by the European authorities, the SRB and the European Commission, holding virtually the very similar or identical arguments in both proceedings. Spain requests the tribunal to declare their own lack of jurisdiction over the claims or, if applicable, the inadmissibility of the claims as a consequence of the breach of these two clauses of the bilateral treaty. By contrast, the claimants deny that any overlap between the proceedings and because at the Court of Justice proceedings, the claims involve different facts, different parties, and legal instruments governed by different laws. The tribunal rejected both jurisdictional objections raised by Spain and decided to sustain and confirm its own jurisdiction over most of the claims. More specifically, the tribunal basically found that the claimants at the Court of Justice only challenged measures adopted by EU authorities. The sole respondent in the court was the Commission and the SRB, and for alleged violations of EU law. And finally, the third lesson I would like to highlight is that the claimant's case in the Del Valle case basically aimed to convince the tribunal that Spain have breached the fair and equitable standard because well before the crisis of Banco Popular, it had orchestrated a plot or setting up conspirational arrangements to sell Banco Popular to Santander. In support of their case, the claimants alleged that Spain have adopted or failed to adopt a number of measures, and some of them were included in the resolution processes or in the sale of the bank, which necessarily involve the coordinated action of the ECB, the Commission, or the SRB as cooperators of this Spanish plot. In the award, the tribunal found that the fact that the claimant's pleadings contain several references to the EU law and to the measures adopted by EU authorities, it is a logic consequence of the new allocation of powers within the banking union between Spain and the EU authorities. In the tribunal's opinion, if it examines the acts or measures of EU authorities, is because this is just form part of the factual background which the tribunal is obliged to look at when it is examining or assessing the merits of the case. The tribunal, indeed, in the award, said that it lacks of jurisdiction over the acts of the European authorities, but because its jurisdiction is limited to the acts and decisions of Spain. So, however, if reading the award, this strong statement is not fully accurate. In accordance with the award, the tribunal analyzed some SRB decisions, for example, during the resolution process and the sale of Banco Popular to Santander, even more in depth than the General Court in the judgment of 1 of June of 2022. Therefore, as the outcome of most arbitrations are highly dependent on factual determination, the question arises as to which is the scope of analysis of regarding the factual backgrounds by the international tribunals. When it comes to measures within the banking union, where the composite administrative procedures are very common, where the decision-making power lies with the European authorities, but the power of the authorities, national authorities, is limited to the preparation or the implementation of these EU decisions. So thank you very much for your attention.
Thank you. Thank you very much also, Ignacio, for sharing the specific views on Del Valle and the conclusions. I would now indeed, we have some microphones here, so I would indeed like to open the floor to the audience for questions. And I'm looking around. Please, Marco, here in front of
Thank you for
the mic will come to you, Marco, then we can all hear you.
Thanks a lot. Thank you to the speakers, very illustrative, very enlightening. A very, very quick question and a curiosity. From your experience, do you expect that claimants may actually receive a different treatment in terms of establishment of facts from arbitrators vis-à-vis European courts? Because one striking point in the Kaufmann-Kohler arbitration is, in the end, the establishment of facts was found to be assessed under the reasonable certainty, but there was a discussion on whether the preponderance of evidence should be applied or the shift of the burden of proof. And since this is a critical point also before European courts, it would be very interesting to listen to your views.
Thank you. I would take the opportunity to bundle, because I think looking at the time, it's probably better to take this or other questions if there are any others. No. So I know there is one question on that side, and then maybe you can also say to whom you would direct the question. Then.
Whoever would like to respond. I have a question. We all know that bank resolution and crisis management is also to some extent about exercising discretionary powers under certain, of course, legal constraints. And it is quite a challenging topic of legal research in itself, how to exercise discretionary powers and how to balance the powers between administrative authorities on the one hand side and courts on the other hand side. So now we have a third player, so to speak, in this arena, which are arbitration courts. How do you see their position in this domain?
Thank you very much. Two very interesting questions. I would suggest that maybe the question from you, Marco, Sonsoles, you and Cecilia and Sonsoles, you reply to, and the question from Rasko, Petra, and Regis.
Sure. Well, thank you for the question. That is very interesting. I will not give a very academic answer, because in my experience, the questions of the standard of proof and the shifting of the burden of proof in cases of arbitral tribunals are taken on the basis of the feeling of what is just in the eyes of the arbitral tribunal. So, and then for the reasoning, they clarify what is the level of the standard of proof. But it is usually considered, at least in international investment cases, that there is no link with the law of the seat. So again, the arbitral tribunal can exercise a certain degree of discretion in deciding which is the standard of certainty. And I would say that the banking sector is not even, or whether or not the decision were lawful in a situation of urgency is not even the case where this is more impactful. Cases of corruption, for instance, there it can really make a big difference as to what is the level of certainty of proof and the rules on the burden of proof that the arbitral tribunals apply. So to give you a short answer, I don't think that there are reasons why the establishment of facts we are talking should go under different rules than in front of the national courts.
Is this also something you would describe?
You know, I think both questions are together, no? In my view, for me, the facts, it's not a problem. You have the facts. The problem is how you assess those facts, and there is where you have two different standards. In case of the Court of Justice, I know the standard because you have the case law. You have not only the case law in relation to SRB, but when we refer to technical appreciations, there is consistent case law where you need to do, in case of institutions, manifest errors. And then I have at least certain criteria. Then we all know that in the specific case, you might have doubts and it's up to the judge to decide. In the case of arbitration, as Petra was citing, it's inconsistent. I don't know. It depends on many factors, and there, of course, that's my view. But then this question, and I have heard this question many times, and not in arbitration. The standard of review. That's the real question, and this is something. It depends on the court. It depends on the moment. Of course, there is more legal certainty, and as regards the Court of Justice, there is this kind of consistent criteria. And the problem is when we have, for instance, new regulation. No, I'm following all this debate about DMA, and we don't have regulation, and what the court has to say. Then we need to see what would be the bar, where the court will set the bar. But in terms of facts, no problem. The problem is, how you manage the discretion, and you said the discretion, the rule of book, and then don't forget about that we are managing crisis, and then we need certain flexibility. I heard that word too. And then where do you mix all that? No. Then I would say a word that has not come up: common sense. This is also quite important, and not everybody has common sense. So that would also, and that's not very legal, but sorry.
Thank you for reminding something also here, all of us, which is important. Petra, what is your take on the second question?
Yes, now I more or less agree with Sonsoles. I had a bit the same. I think, of course, the review by the arbitration tribunal is very much defined by the agreement within which they operate. So normally, I mean, the ones I know best, it's always that agreement and international public law. Now the question is, a bit going back to my presentation, how is EU law approached under that international law prisma? And there you have a wide array of opinions, and that's a bit indeed the problem of the unpredictability. So I think from a member state, EU law is national law and must be observed, and a diligent investor must take that EU law into account. But then when you go to arbitration and some of those awards indeed dismiss that important angle of and that important part of the legal framework within which investors operate in the EU, I would say that's quite worrying. And I think that's also where the discretion probably goes even beyond what is defined in as the source of law that arbitration tribunal should observe. without specifying.
If I may, just very quickly, because I think the second question was specifically on what is the standard of review of the discretionary power, and I think, as Régis pointed out, I mean, for international law, the dividing criteria is whether there was a violation of the fair and equitable treatment and whether there was any discrimination. So in that respect, the standards may be different in front of international tribunals and in front of national courts, which is why it has happened that foreign investors have a better treatment than local investors in the same country. Not speaking of the banking sector, but for instance, in the Vattenfall case, that was a big issue of a debate. But there I would say it's not so much a point of the arbitration instrument. It's a matter for the European legislator as well to consider why this situation occurs. And the purpose of international law is to protect foreign investment. So international law is doing what it's there for. The problem is if the European remedies, maybe this I share Sonsol's view, maybe the European remedies are not, maybe they are there, but they are not effective enough, or so that's something one should be looking at.
That is true. Régis, I will not ask you to also answer this question. I would ask you something else more forward-looking. Where would you see the trend going in this debate between jurisdiction, so judicial review, and international arbitration? What is your take on that?
Well, this was the orientation of the answer I wanted to give to the last question, so that's perfect. You're reading my mind. The fact that whether or not it's a third player, I don't see it as a third player. I see it as a second option, as another option for, the claimants. And clearly, when we see, for instance, the Banco Popular case and the experience from the Banco Popular case, really the banking authority is not at ease, with this new world of investment arbitration. Investment arbitration at the beginning was not designed for this kind of disputes. And I would say it's almost, Barcelona playing at the Real Madrid stadium, you were not at ease, in that context. The context was completely unpredictable. And to some extent, it is. We have this European judicial review system. We have this possibility of, administrative responsibility even of EU institutions within the EU. The question is, what's going to be the future of investment arbitration in that regard? Yesterday the EU decided to withdraw from the Energy Charter Treaty, so thus can be used only by claimants for energy-related disputes, not for banking disputes. But there have been many changes in the way the EU of other states have drafted, for instance, their fair and equitable standards. There have been changes in the EU. There have been changes in the US, for instance, with the new NAFTA, the USMCA, and even under the USMCA, in certain circumstances, it's no longer possible to make a claim on the basis of a violation of fair and equitable treatment, but only on the basis of non-discrimination. And this leads to, how the tribunal is going to interpret these standards, because there has been a backlash against, the fair and equitable standards, because it gives too much latitude to the arbitrators. Even though I've tried to show that, to some extent, the arbitration community, the arbitral tribunals, have understood what were exactly, the constraints of the banking resolution system. But, there is still a risk, because arbitrators were able to read a lot into fair and equitable treatment. And actually, if tomorrow we just stick to non-discrimination, as an arbitrator, anyone can read a lot into non-discrimination, in non-discrimination standard, if he is inclined to do so. So I think the system, the question is not really what's really the judicial review, because we can see that there have been inconsistencies. The question is what states actually want to do with investment arbitration also in the future. Yeah.
Thank you very much, Regis. I think we are coming to an end, not so much to a conclusion, because I think what we started today was really exploration of this topic, which is an emerging one. And we will have, maybe in the Swiss case, also more material to study. So thank you very much to the eminent panelists for your presentations, for answering the questions. Thank you very much to the audience for your interest, attention, and again, the questions. And now I think we can continue over lunch. We all have deserved it. Thank you very much. Thank you.